May I have your lordship's leave? Your lordship remembers few days ago I mentioned. Your lordship list shows it, and it shows at 105. I'm requesting your lordship to take it up sometime in the forenoon, 12:30.
But you are telling that the similar appeal
Similar appeal has been admitted. I'm sorry,
can-
Milord. I'm not
doesn't matter.
not because
We can admit it and post for final hearing.
your lordship may do that.
Because
This is writ appeal 154
154.
of 2025, admitted on 4th of March 25.
Yes.
Union of India's appeal.
Yes.
Milord, if your lordship is pleased to admit it, I'm grateful. But I am requesting a date for hearing the stay petition.
Stay petition.
Yes. Not today. I understand that.
No, we could have considered, but in this it is not granted, so we have to follow this. Readily it will not be considered. First we'll admit and they will see what to do.
No, Milord, I'm only requesting a date
That we
for hearing the
Yes.
stay petition.
So give that 105, 6, what? So your file leave to appeal also.
Leave to appeal because I was not a party in the writ petition. I'm a third party affected by the judgment.
The other side would have to be put to notice.
Milord, we have served them. The Union of India's appeal is there. I could,
So kindly ask the instructing counsel to inform the other side and we'll take up at 2:30.
I'll instruct them.
2:30. So that leave to appeal can be granted and the appeal can be admitted.
All right, very well. 2:30, Milord. 2:30, I'll come
To
back.
inform the counsels who are appeal.
My lord had, I'm so sorry. I'm so sorry. My lords had been very pleased and very kind to give me that liberty.
Mr. Counsel, you are enjoying the interim relief.
I am, my lord, but there are certain developments which have taken place by your lordship's order. The Labour Court has given its opinion. Unfortunately, the other side has already challenged it before a single judge who passes an order saying that his order should be placed before my lord. That is what has happened in the interim. So if your lordship just gives me 10 minutes, my lord, this matter can be disposed of within 10 minutes. It will not take longer than 10 minutes.
In the second half.
Very well, my lord. 2:30, my lord.
Which is the number
108, my lord.
in the second half? 2:30.
So obliged.
Yes, madam.
My lord, serial number 47, my lord. Serial number 47. Only next week, my lord. I have a petitioner, my lord.
No, next week. It will go to June, 25th of June as
Much
requested
obliged.
by learned advocate for the appellant. Yes. Yes, Mr. Yes, ma'am. Yes, ma'am.
My lord, serial number 81 and 82, my lords. We are appearing for National Highway Authority of India. In that matter, the warrant has been issued today through special amina. It is going to get executed today. Matter may be taken up at 1, my lords. Serial number 81 and 82, my lords.
What is issued warrant
Yeah.
in execution?
Yes, my lords, in the execution.
So what is the matter? 80 and 81 both?
Yes, 80 and 81.
80 and 81. So one is writ appeal, the other is miscellaneous.
No, my lords, 81 and 82. It's MFA.
No. 2:30?
Grateful, my lords.
2:30.
Lords, there's been an encounter killing in Hubli Dharwad district, my lords, and there is credible information that the body is likely to be cremated anytime soon, my lords. A stay maybe, we are filing a writ petition, PIL. It's just caught up in logistical delay. An immediate stay may be like passed, my lords, and also informed to the concerned police authorities.
Two more.
But a stay may be granted, my lords, because there is credible information that the body may be cremated.
We don't adopt practice of listing the matter on the very day mentioned, tomorrow.
My lords,
With my lords,
Yes.
kind leave. My lords, I'm praying for certain
Yes,
matter.
complete the, yes.
My lords, there is credibility. They it's
You should have
evidence,
filed
my lords.
yesterday.
My lords, yes, yesterday it has come up, my lords. Like we got very.
What has happened?
Basically, my lords, this was a encounter killing, my lords. There are news reports to evidencing the same, and in Hubli, Dharwad, and
Right.
if the body is cremated, it's going to be destruction of evidence, my lords. We are seeking a special investigation. There's another. My lords, it will prejudice the free trial of this matter, my lords, and investigation will also be jeopardized if the body is cremated. It is the police state authorities itself who are allegedly like under. My lords, because yesterday was a holiday and today it came up day before yesterday, my lords, but it came to our awareness yesterday, my lords. But there's been a logistical issue. They're stalling the filing itself at the counter. That's the problem.
What is the problem?
I mean, they're not the filing is like being stalled because they're saying there are some bureaucratic like there's some checklist that has to be done. We're doing it, so that's the delay, my lords.
In the second half.
Yes, sir, but
Subject.
until then, the direction may be passed to like not cremate.
That we
the
do not
body.
know what direction, what is to be done. Let it be listed in the second half. Subject to removal of office officers, with copy to be given to the learned, the government advocate in advance.
Lordship, kindly, my lord. The art impugned is passed by the learned single judge without notice to me, though I was imputed in the writ petition. Without notice to me, though I was imputed in the writ petition, and it is adversely affecting me. And may I request for a date, my lord. The arts passed by the learned single judge without notice to me, though I was imputed in the writ petition. So it is adversely affecting me.
What is that? You tell us.
But the
General
learned single judge held that survey cannot be taken up in respect
We are
of
not interested. What is that matter? Appeal, PIL,
appeal, writ
RFA.
appeal.
So
Writ
what is the
appeal.
urgency?
Writ appeal.
What is the urgency?
But the learned single judge held that the survey cannot be taken up in respect of urban properties. You have to file a suit inter-alia taken up.
Very good. File a suit then. What is wrong in it?
No, the division
That
bench
is
of-
not urgency. That is not urgency. You may be right in your submission after vacation.
My lords, kind leave.
List it on 18th of June. Yes.
the
With my
sixth
lord.
date is already given. Sixth date is already given.
January the question.
I'm sorry.
With my lords, kind leave. Certain writ appeals which are listed today, my lords, regarding pro rata charges, constitutionality of the provision in the BWCSB Act, my lords. I'm requesting for clubbing of the matters, my lords. One writ appeal is not listed, my lords. This is the memo requesting for clubbing, my
There are the
lords.
numbers.
My lords, I'm handing over the number.
In today's
Please, my lord, in today's list, my lords.
so it will go after vacation.
Yes, my lord, may be called after vacation. One writ appeal which is not
Request of
listed, my lord,
learned
I'm
counsel
furnishing
from
that
all
number as
these
well.
appeals shall be listed next on 27th June. In addition to the above matters, writ appeal number, whatever, shall also be listed.
In
which
seal
is
number 86, my lord,
Cognate appeal, yes.
in one of the matters, my lord, am I permitted to serve the counsel who appears on the panel advocate, my lord?
You do it, whatever you want.
Please, grateful to my lord.
Serial number 73, my lord.
73.
3, fault is appearing personally. He is admitted to hospital in Kerala. Kindly have 10 days time, my lord.
My lord, this has been coming up for a long time. The party in person doesn't appear.
He is admitted to hospital in Kerala, my lord.
Who?
He is a actually handicapped person, petitioner himself.
Hmm.
So kindly accommodate 10 days time because he had to recover from the, on the health issue he was asking.
Since it was stated by learned advocate, Mr. What is your good name?
MT Jagan Mohan.
M.K. Jaganmohan, who appears on behalf of the petitioner party in person. That the party in person is admitted in a hospital in the state of Kerala.
Yes,
Kerala.
Kerala, in Kerala.
Where?
Kozhikode, I think some, Kozhikode, some place.
What is the place? Ojikodi.
Kozhikode.
Give name in the state of Kerala. In that view, we request at the time stand over to petitions and to stand over to 30th June.
Memo for posting, my lord. It is an MFL. The arbitrator's award of enhancing the compensation was challenged before the Union District Court. And award has been suspended. Appellant is more than 90 years old, and I have also complained the office objections, and the matter has not been listed since 2 weeks.
23rd. 23rd.
Lordship permits me. Serial number 36, my lords.
Serial number?
36. Serial number 36.
My lords, I appear for the appellants in serial number 36.
You are 36.
I am for respond number 2 and 3, my lords.
My lords, I
I am
have,
for respond number 2 and 3 in the matter. I am filing my objections today. Your lordship may have it any date.
my lords, we have strong
Let
objections
it
to
be
this
called.
matter
This is
being
regarding some
adjourned.
allotment of land.
37. They
Yes,
have
my
an
lords.
interim order in their favor.
No, let it be called out.
Let it
The-
go on, my lords. We are ready
The
to argue the
learned
matter.
advocate general appeared and they were to identify the land. That is
36, my lords, 36, it's an MF.
36 is what?
Arbitration matter.
36 is 36.
36.
My lords,
not
we have
content.
strong objections to them taking time, my lords. We've been ready to
You are
argue the
appearing from
matter.
Ms. Chinnappa.
For the appellants, my lords.
For Chinnappa.
Yes, my lords.
Therefore it is mistaken.
Please.
36 also you are appearing.
Yes, my lords, 36.
I am for the caveat respondent. On 7-3, my lords, your lordships have passed an interim order.
What is it about?
It's about 37 challenge to award, my lords, arbitration award. I'm filing my objections today.
My lords, we have strong objections to the matter being adjourned, my lords. We are ready to argue the matter. May it be taken up today, my lords.
When you are going to file?
During the course of the day, I'm filing my objections.
My lords, let it be taken up today, my lords. I am
Let
ready
it be
to
called
argue
out.
the
We'll see
matter.
on that.
Great.
Can you mention through VC, sir?
Lords, serial number 98, Lords, in the, this matter was listed at 2:30 on the last occasion, then your Lordships gave the date, Lords, on today. Lords, in the event of the matter not reaching today, Lords, may request can be taken up day after tomorrow or on Monday, Lords, at 2:30. I have informed Lords the other side.
Around 24.
Yes,
24.
24th at 2:30, Lords. Very well, Lords.
If any urgency will take up.
Lords, there is an urgent, Lords, I had made a mention because of which your Lordships, Lords, because of an interim order which is passed in this matter, there is a docket explosion, Lords. Almost about 18 writ petitions are filed based only on the orders passed by this honorable court. And 13 contempt petitions. Lords, it's multiplying, Lords. The litigations are multiplying because of this. 23rd, can I request, Lords? There is 23rd at 2:30, Lords.
23rd. 2:30 we'll see in the next week because it's last week, almost last week before vacation.
Please, I'll take a chance at 2:30, Lords. 2:30. Great, Lords.
Interim order may be extended.
In all the cases, interim order requires to be extended, Lords. There is an interim order operating.
Interim order may be.
To be extended.
Please, Lords.
Office objections have to remove.
Lords, that is only in respect of one of the matters, my lords. Other matters, your lordships have granted interim order notwithstanding the objections.
If substantial office of there, then remove.
Please.
Yes. Next.
Any other mention through VC, sir? Still number 1, Mr. KP Bhuvan.
Lords, complainants counsel by me in this matter, my lords.
My lords, today the review petition is listed before the Honorable Dharwad bench, my lords, in the special list, it's been listed, my lords, and it's been heard at 2 o'clock. There's a special list on our request, it's been listed, my lords, today.
Lords, 27/3/2025, your lordships passed an order. Lords, the difficulty with the mindset of the government is this. Lords, they feel that any order is capable of being flouted, and ultimately they can come and say that this is what has happened, that's what has happened. My lords, the reason why I'm submitting this is if your lordships were to see the order stated 27/3/25, a specific direction is given that if in 1 week, if they are don't secure the orders, they will have to comply. Let's see if ultimately the order review is entertained. Lords, they are entitled to Lords, restitution. They can Lords, trace their steps back. But this is an aggravated form of contempt on their
Date
part.
is listed at 2 o'clock.
Today listed 24th.
Please, my lords.
Obliged.
Lords, your lordships may say for complaints by 24th, my lords. In the meantime, if there is any order passed in the review
Then
petition, I
our RP
understand.
will become infructuous, my lords. 24th it may be listed.
Since the review petition is stated to be listed before the Dharwad bench, today itself, the present contempt proceedings stands adjourned to 24.
Please, my lords.
This is number 2, Mr. Wakul.
Represent Appellate's Counsel. Page number 15, para 7 is the directions issued by the Honorable Court. The land of the petitioner was utilized without there being any acquisition proceedings. Direction to comply it within a period of 4 months.
Nothing has done.
Nothing has been done.
Notice returnable on 5th of June.
Still number 3, Mr. Ravish.
Your Honor, I am for the complaint in this case. I have filed a withdrawal memo, Your Honor.
Withdrawal. Where is it? Figures on record. Memo of withdrawal. Where is it?
Copy.
Memo I have filed it in the counter. You want copy? It is a OC.
Pass it
2
on.
copies I have filed there.
Today, you have filed it today? You have filed it?
Yes, Your Honor.
You have filed the memo of withdrawal?
I have filed already. I have filed in the counter, Your Honor. So today morning.
This is to be taken on record. Okay. Okay, you get it on record. Figures on record. Memo dated 15/4/25, filed by Leonardo complainant stating that the complainant wants to withdraw the present contempt petition. View that they want to work out their grievances in the execution petition number 1478 of 24, pending before the City Civil Court. With liberty reserved as above, but without expressing any opinion on merits, the petition is permitted to be withdrawn and stands dismissed accordingly. As withdrawn.
This is number 4, Mr. A.S. Mallikarjun Swamy, party in person.
Mr. Man. My lord, I'm a complaint, my lord. I'm suffering from very lot, my lord, from 2014 till today. There's no relief. My name was, I'm a lecturer in physics, full-time lecturer in physics in Marimala PU College, Mysore. My name was recommended grant made in the year of 2009.
It is written on 16th June.
This is number 5, Mr. Durgekar Sujata Vidya.
Yes.
My lords, the complainant is before this honorable court because the accused has willfully, deliberately disobeyed the order of my lords and has disrespected the order where the complainant society was formed under the directions of this honorable court, my lord. But he says that he does not recognize the society and there has been a continuous violation of my lord's order by immediately closing the temporary office of the board, which was formed under the directions of this court.
Where is the direction?
Directions, my lord, is on page number 38. where the writ petition, the accused has permitted the few owners of the blocks without OC to illegally occupy the premises. They had filed a petition, my lord. That petition was dismissed and the society was upheld and the direction was given to
So
conduct.
appellate authority is to decide the appeal. That's all.
My lord?
Appellate authority is required to decide the appeal. That's all. That is the only direction.
No, my lord. The board was formed under the directions of this court, and my lord's order has upheld on 44 page number, where it says that the appeal which was filed by those illegal occupants of the apartment as infructuous, and the elections was upheld to the board. The board being constituted under the directions of this court, the accused says that he does not recognize, and subsequently there was a writ petition filed by the wives of these same illegal occupants of the apartment, my lord. In that also, in the objections, he states again that on page number 53, he says he does not recognize the society and the act of closing the temporary office of the board.
To show us the direction which are not complied with.
The board is functional is the order of this honorable court, where he's obstructing the functioning of the board by closing the act of
From
closing.
the order of the learned single judge, or even from our order confirming that, show a line which is a direction to be complied with.
He should allow the board to be functional.
Show the line which is to be complied with. Where is that? There must be a positive direction in order to allege contempt.
The elections are held, the appeal has become infructuous and the board has become functional, my lord. But he is not allowing the board to function. That itself is disobeying and disrespect towards the order of this honorable court, my
Who
lord.
is not allowing?
The accused, he is the builder. And in various forums, he is also stating that it is an illegal society and he is harassing the board members. And the members of the cooperative society also he is harassing, my lord. This is disobedience towards my lord's order. Because the elections itself is under this honorable court directions. And the board has been formed under, and the board only is not respected, my lord. He has removed the sofa.
We already stated that the elections are held and the board has become functional.
Yes, my lord.
The statement of law, it operates. Whosoever, any person may say anything. This will operate, that board has become functional.
But he is not allowing the board to function. That is disobedience towards this order, my lord.
File a writ of mandamus. File a petition. There is no contempt here, that's all.
He is disobeying, willfully, deliberately disobeying.
Where is the direction which is not obeyed?
The functional part of that, the board being elected under the directions of this court.
There is no direction.
Because the society itself is formed under the directions of this court, my lord, and he is not allowing the board to function. And the various emails on page number, the subsequent contact also shows his continued violation of the order, my lord.
Learned single judge, by order dated 22nd January 2024, dispose of the petition with following observations expected herein below, which are paragraphs 13 to 17. So quote 13 to 17. The aforesaid order was taken in writ appeal number 19024, which was not entertained as having become infructuous. As per order dated 23rd September 24, the said order of the division bench in its relevant part reads as the said order is extracted, reads as under. So entire order you quote. Full stop. This contempt is the present contempt petition is filed in respect of alleged non-compliance of the above orders. From the either order, whether of the learned single judge or of the division bench in the writ appeal, from a learned advocate so and so, is unable to point out any positive direction in respect of which the non-compliance could be alleged and contempt could be,
My lord, on submission, my lord.
in respect of which the contempt could be alleged. Also, in any absence of any positive direction, the contempt petition would not be maintainable. For exercising the contempt power, there has to be a positive direction required to be complied with by the respondents. Also, on the order of division bench, it is unequivocally stated, the inward comma, the elections are held and board has been functional. Full stop. The above statement of law already figures in the orders to operate to its logical end. Full stop. However, no case is made out to exercise the contempt jurisdiction. The petition is accordingly not entered. So the grievance is taken care of. Next.
Obliged.
This is number 6, Mr. Vinay.
That's the orders at page 13, relevant portion page 21, para 16, bottom, and para 17.
Not invested.
Please, Lord.
Amount is not
No,
invested.
not.
Notice returnable.
Please.
We'll say 29th of this month.
Please.
We will serve by direct by hand delivery.
Very well, Lord.
Service to be effected by hand delivery.
Please.
29th of April.
This is number 7, Mr. Mohammed.
I am for the petition. But kindly come to the page number. Kindly come to page number 15, my lord. The order, my lord, passed by this honorable court. There is an illegal construction, my lord. My lord, upon being satisfied, my lord, his lordship, my lord, was pleased to pass an order direction. My lord, come to page number 18, paragraph number 6. My lord, however, my lord, got it. However, the BBMP is directed to ensure that the proceeding that has been initiated in respect of the unauthorized construction made by the respondent number 4, my lord.
Notice. 10th of June.
My lord.
10th of June.
Pardon, my lord.
Notice 10th of June.
10th of June. But can it be 6th of June, my lord? Because I'm coming from Kolkata, my lord. In Kolkata, Calcutta High Court, my lord, there is holiday. 6th of June, my lord, my lord,
5th of
June. 5th.
5th.
5th, my lord, I have difficulty.
You want 5th?
6th, my lord.
6th.
6th.
Because you are smiling 6th of June.
Obliged, my lord.
This is number 8.
Yes, my name may be recorded. Brotin Kumar De, my name may be recorded.
Heard learned Mr. So notice returnable on 6th of June.
This is number 8.
Thank you for the petition. Complainant Lordship. Lordship, complainant is a student. He had scored 49.5% marks, Lordship. And the learned single judge has directed the accused to round off to 50, Lordship, and issue fresh mark card. And the order is not complied. And there are similar petitions have been filed, Lordship. Serial number 83 is one such petition. Along with that, there are other petitions which needs to be called along with this contempt, Lordship. In the meanwhile, the RGHS and the NMC both have filed writ appeals. And as on today, they have not complied with the orders, complied with the writ appeal, Lordship. And
you want this contempt to be heard with writ appeal?
Writ appeal, Lordship, and they are not complying with the office objection and dragging the matter.
Wait till it is called out, writ appeal. Keep it.
Lordship, it is writ appeal is not listed. It is not at all complied, Lordship.
Then we'll receive notice returnable on 4th of June.
Lordship, the exam starts, supplementary exam starts on May end, Lordship, and last date for filing the court fee is 21st of April, Lordship. I pray for a shorter accommodation, Lordship.
Last date, there must be a provision for late fee also.
Lordship, 13th May, Lordship.
Late, 23rd of April, notice.
Lordship, the details of the writ appeals and contempts.
We are issuing notice in this contempt petition,
Please.
written on 23rd. Service by hand delivery is permitted. On that day, you may point out this appeal.
Seal number 9, Mr. Rohan.
This is the last
Has
time it
been,
was-
I think, my lord, with the intervention of the learned AG, my lord, there has been something.
We have sorted it out.
More or less sorted out.
Back to work.
Please, Mala.
Back to work.
Back.
Please. In fact, same memo my learned
I
friend
think
also
my
has filed.
learned AG is coming with good news on his comeback, my lord. After coming back, he's coming with some good news.
After coming?
After coming back to work, he's coming with some good news, I said.
Maharaj, this is a case where we lost before single judge division bench Supreme Court, Maharaj. But only
you have to identify.
we have identified a
We have
produce a sketch
identified
also.
a certain land.
Page
Now,
9 may
further
be
steps will have to be taken.
Page 9, my lords. Same thing. Yeah, fine. Page 9, my lords. Just last paragraph, my lords. They have marked and designed the land on industrial area map and no objection for allotment of 300 acres at bulk rate, including cost of land acquisition and board service charges. Finally, the chief executive officer and member stated that as per the request of so and so, allotment will be made in accordance with the allotment regulation by collecting allotment cost after obtaining approval of the board. The land is earmarked, sketches produced for your lordship and consideration.
Yes, yes. That we have accepted.
They have
But there are further steps to be taken.
Modalities you complete.
Yes, no. Lordship, may have it after 6 weeks maybe.
No matter, it will take minimum 5 months. It will take, my lords, because we have issued 28-1 note. They are aware of it, my lords. We have issued only preliminary notification at 28-1. Objections, final notification, possession. As per the act itself,
You are requiring.
rules as per the act and the rules, it will take so much of time.
You are requiring and giving.
Giving it to them, my lord. They are aware of it, my lord. That we have issued only 28-1. There are other lands.
We have no objection.
Can I make one request, my lord?
We'll put after vacation.
No, can I make one
May have it
request?
after vacation.
Progress
We'll
can
see the
be-
progress.
That's all.
I have no problem.
Nothing more. We trust you.
We please.
They also trust.
We also trust. I learned.
Learned but Advocate General Mr. Shashikaran Sethi, sorry, sometimes so like a singer who goes out of memory. It is some kind of I'll say affidavit. Along affidavit dated 15/4/24, in which produced is the copy of proceedings dated 7/4/25 of the committee of the meeting of KIADB held regarding the allotment of 300 acres of land to Messrs. Cornerstone Property Developers Limited. Full stop. The land is identified as described in the land as described in the affidavit is identified and is being acquired. Full stop. A map is also produced depicting the location of land. Full stop. It was stated that procedure of acquisition shall consume some time, before which the possession could be handed over to the petitioner. In this view, to be listed next on 18th June, on which day the progress shall be reported.
Yes, please. I'm great.
Seal number 10, it's a PAL.
Nobody is there. Stand over to 25th of June.
Seal number 11, Janpama Giappa.
This is that matter relating to Kambalam.
Is it really urgent? Then we'll let it. Otherwise, not. Otherwise,
Yeah.
after vacation. Committee report is given.
Committee report
Already.
has come, then Lord, there is an application for implement. Now, there's one more difficulty, Lord. Shimoga, they want to do it now.
No, let them, wherever,
No.
other,
Shimoga.
insofar as, my lords, Shimoga, we are given undertaking insofar as Bangalore is concerned, my lord. Rest of the thing, my lords, we'll go ahead with it, my lords. They have filed for application and we are going, because otherwise, after vacation, my lord, in fact, my lord, this tradition has been going on, Supreme Court has already dealt with. So therefore, insofar as Bangalore is concerned, I had made a submission, we will, till your lordship,
Pilikula and Bangalore.
Pilikula
Pilikula
is
and
concerned.
Bangalore.
I stand corrected, my lord. Pilikula and Bangalore, I had made a submission.
Shimoga
I'll
also
make an
stands.
argument on merits. I'm quite rest of the places, my lords, let it
But
go.
Shimoga, my lord, is also outside the territory, my lord, of Uttar Kannada and Udupi. That is the locations, my lord, which they have themselves told the Supreme Court as being the only locations where they can carry out Kambala. And it was on that basis that the Supreme Court ultimately upheld the validity of the amendments to the law. Today, my lord, to say, now, my lord, they say, next we'll do it in Mysore, then we'll do it in Shimoga. It, in my humble submission, runs contrary to the very intent of that act, to say that it should be geographically located at those places where Kambala has been traditionally conducted, not to expand the scope and move animals here and there.
Malat, I'll just show a few paragraphs of Supreme Court
And
judgment.
it's never
Malat.
been held in Shimoga.
No, should be able to show it's clearly covered, saying that we can do it throughout the state. If your lordship, if that is wrong, I have no case, Malat. Just few paragraphs. Malat, I made a submission because matter was not fully ready insofar as Bangalore is concerned and Pilikula, Malat. I'll make my good at the time of final argument. Rest of it, my lord, my learned friend, in view of the paucity of time, Malat, let it go on because it has been going on, Malat. One other aspect, Malat, your lordship may kindly see, horses travel throughout the world. They have no objection. Here, 120, 130 kilometers, only they are traveling. My lord, you should not have any objection with Rafa.
This is the place where you are holding near the zoo.
Shimoga, Shimoga, my lord. 120 kilometers, my lord, inside Mangalore.
Near the zoo.
That is Pilikula.
They are not doing it.
That is the present issue.
That is, no, there are two.
Now
they came up with a third place now. When the petition is pending, they came up and now said we want to do it in Shimoga.
Let them file a fresh
What about this zoo?
My lord, I took an undertaking. I will not do it till your lordship hears. That is what I'm making a submission. My learned friend cannot keep filing applications after applications in the two issues are in the main matter.
Now you want to held in Shimoga.
Shimoga.
Please, my lord.
What is your objection?
Shimoga, my lord, in my respectful submission, comes outside
You're going back to the original pleading.
Original issue only. The issue of geographical location. Lord, in Pilikula, your lordships recollect, Lord, I did not raise the objection of geographical location. The reason was Pilikula is within the geographical location, but next to a zoo. So it was a completely different issue. The other issue is, can you do it contrary to the statement made by you before the Supreme Court? That is only in two areas where I'll do it.
But now that pleadings are there in
Full
regard.
complete.
Yes, pleadings are there.
IA is filed only
I
today.
filed an application.
Just now.
My lord, original pleadings.
Who has filed IA?
I filed an IA, my lord.
No.
In the original pleadings, I have specifically said outside these two locations because my lord, I did not come to your lordships, not making an overall statement that you should not hold it at all. Now, once the Supreme Court has held that it can be held, where can it be held is the
I'm
question.
sorry, my lord, Supreme Court was not held. Let him show the paragraph. There's no case. Your lordship may come.
No, please don't miss. 1 second, learned age, please wait. Lord, the issue was, what did they tell the Supreme Court when they filed an affidavit? And I'll show your lordships any number of paragraphs, at least 20 places where they've said that Kambala is geographically carried out for centuries only in Dakshin Kannada and Udupi districts, nowhere else. And it is on that is the affidavit before the court. Once they file an affidavit before the court, can they now come and say, I'll do it in Bangalore, Shimoga, Mysore? Yesterday I saw a newspaper article saying I'll do it in Mysore during Dasara. This can't be, it was almost like an exception to the rule.
Want to take up IA, then we can take up day after.
Very well.
My learned friend, let him, instead of making a submission, Supreme Court has told Supreme Court, let us go directly to the Supreme Court judgment, what the Supreme Court has told. Because with great respect, what my learned friend is arguing is not forthcoming from the Supreme Court judgment. I understand.
Tomorrow we can take it.
Please,
Yes,
my lord.
Let us.
Please.
Very well.
Where is your IA?
IA, my lord, is.
IA number?
Sorry to trouble your lordships. I understand, my lord, because before vacation, sorry to trouble your lordships, my lord, because otherwise we would not have argued the matter. The reason is, my lord, what was the main subject matter was Bangalore and Pilikula, my lord. We said, because the matter has to be argued, we said we'll stay off till your lordships hears.
Now probably the very ground they urge in this program, Bangalore, they are urging here.
For Bangalore, same ground here. Please see my prayer, my lord. My learned friend may not be right.
IA?
IA number 3, my lord.
Has
Copy is not at
3 of 25.
So, Date I ಕೊಟ್ಟಿಲ್ಲ.
Served.
Anyway, it's okay.
You have a copy?
He gave it to me, no problem.
My main prayer itself, my lord, is specific. Para 12, page 12 is my prayer, my lord.
Page 12.
Page 12. Honorable Court, be pleased to restrain the respondents from conducting or issuing permission of the
When they
conduct.
are, what is the cause of action to file this IA?
They came, my lord, and told the court last time, the committee made an application to implead themselves and said, we are holding Kambala in Shimoga now.
When?
IA number 2 of 25.
When they are holding?
They filed it
Date, when is the date?
No, no.
last week. No?
19th, my lords, 19th.
You're going to hold in 19th of.
No, they are holding on 19th. When is your fault? They're not conducting, then problem solved. Yes.
I think they are hearing us better than the statement.
You came late.
Oh, in Shimoga, they're not conducting?
Better late than never, my lords.
So put up.
Better later than never.
All right.
We are for whom?
That is?
You are not holding.
That is? Please, my lord. They are conducting, they are not conducting, then it does not arise, my lord.
You filed IA, madam.
IA 8, my lord, but we have impleted last date on 19th, so it's not been allowed yet.
Already implemented.
Not
We
yet,
have
not yet impleted. Not yet
It
impleted.
was scheduled to be held on the 19th. On 19th, they are not holding it by learned friend's submission.
When are you holding it? Are you holding it or canceling?
holding it.
Not holding it. They're not holding it. So,
Learned advocate miss.
So your
We
lordship.
grant your IA
Okay.
and then lastly we record the statement. Your official good name?
Punya.
So and so states. Lion, where is the
Court of.
IA number 1 of 25.
It was filed on 21st March 2025. Can I give a copy of the IA, my lords?
1 of 20.
21st March 2025. IA number?
1 of 20.
IA number 1 of 2025.
Your Tungabhadra Jodukare Kambala committee. Tungabhadra.
Correct, my lord.
So we grant this
Application.
in the main public interest petition, the present IA is filed in the main public interest petition where the controversy is about the legality or otherwise and permissibility of otherwise for holding the buffalo fight called Kambala, the present application is filed by Tungabhadra Jodukare Kambala Samiti, Shivamoga, seeking to implead itself in the proceedings. The case of the applicant is that it may be permitted to that the event Kambala is deeply rooted in the cultural tradition in the region and that it should be permitted to be held. It is stated that the Samiti is interested in the subject matter and the outcome of the petition. Full stop. Having regard to the status of the committee and the area of activities it discharges, it cannot be said that the applicant committee is alien to the controversy or that is a bystander or a busybody. Full stop. The applicant could be considered as proper party to be implemented. In that view, the present application is granted by permitting impleadment of the applicant Tungabhadra Jodukare Kamala Samiti Shivamoga as respondent respondent in the writ proceedings. Also, the present application is allowed. Full stop. At this stage, learned advocate Miss so and so appearing for the impleading applicant Samiti stated that the Kambala event, which was proposed to be held on 19th by the Samiti, is not going to be held on that day, and that the next date is not certain. Not sir.
Not scheduled.
Not sir. Full stop. In that view, the main proceedings are adjourned.
With my lord's permission.
Separate order passed for this main petition. That learned advocate
But let
is
them
also
not hold it
for
not suddenly. I don't want to trouble the court. Let them not hold it without leave of the court.
stated that the Kamla event will not be, Kamla event which is proposed to be held by the committee at Shivamogga will not be held on 19th, and no date of holding the same is fixed as on date. Full stop. In that view, the writ petition is adjourned to 24th of June.
With my lord's permission.
One second. It is provided that, kindly listen, Madam. It is provided that if the Kamla event is going to be, is proposed to be held in future, for my 15 days notice shall be given.
Yes.
Petition.
Great.
There is another IA that has.
15 days advance notice. Advance notice for clear 15 days, like a statement. Shall be given.
Please, my lord, there is an.
Understood or not?
Yes.
There is another IA before my lords, IA number 2 of 2025, which is also an impleading application. This applicant, my lord, is the former director of the Pilikula Biological Park. So he seeks to be impleaded only to the limited extent of Pilikula, nothing more than that. He has nothing to do with Shimoga nor Bangalore.
Well, that will grant.
Please, please.
Wait.
We have saved 1 day, Manu. Saved 1 day of hearing.
Now there is a saying in Gujarat, always becomes true when the vacation nears. Raat thodi and West Jaja. So we have few nights, but many ropes to be.
No, that is.
That's
Every day we have to watch for the calendar.
Thank you.
Grateful.
So green bench matter, seal number 12 to be a Halaswamy.
Well, yes.
Annexure A, my lord, this is an order passed by the second respondent deputy commissioner, my lord, reserving the land for a solid waste disposal unit, my lord. Kindly come to page 27, my lord. These are the, my lord, the tank which is the only source of potable water, my lord, for the 40 villages, my lord, at page 27. This is the Illy area, my lord. Entire this 77 acres. This is the Ilok, my lord. At page 27, my lord, from 27 onwards, photographs I have. My lord, enter the rainwater flows down to the this tank, my lord. 100 acres tank, my lord. No authorization, my lord, has been obtained by the pollution control board, my lord. This is where, my lord, this is the municipal body, my lord. This is where the local authority, even the local authority wherein the land is situated, my lord, they have passed a resolution opposing this, my lord, for the grant of land in favor of the fifth respondent, my lord. The water stream is running down this Ilok, my lord.
We'll see grant and
Which flows into the tank, my lord.
You have filed this as a PIL?
It's not a PIL, my lord.
Not a PIL. Then what is your interest? What is your personal interest?
Personal interest, my lord, they are the panchayat president and vice president of the local body, my lord, wherein the land is situated, my lord. The entire village will be affected, my lord. Not only one village, my lord, the 40 villages, kindly see, my lord, this is where, my lord. No, consent, my lord, as required under the rules, my lord.
Who are you? Number, both of you?
Pardon me?
Who are the petitioners?
Petitioners, my lord, they are the office bearers of the panchayat, my lord, where this is president and vice president of Gram Panchayat, my lord, which wherein, my lord, 40 villages comes under this panchayat, my lord. The land which is identified comes within this panchayat area, my lord, for the fifth respondent, my lord. Now, kindly see for a moment, my lord, authorization, my lord, under Rule 3, my lord. It's a consent has to be given by the Pollution Control Board, my lord. There is no consent and
You treat this as PA. You file
can
this
be
as
treated as a PL also, my lord.
So you supplement the pleadings. Learned advocate Mr. So the petitioner submitted in course of the hearing that the present petition is filed by the petitioners who happens to be the members of the panchayat, may be treated as public interest petition. Full stop. Full stop. Without expressing any opinion on that regard, comma, permission is granted to the petitioner to convert the petition as public interest petition. Full stop. The necessary pleadings required to be incorporated to make the petition public interest petition shall be supplemented
I will supplement it.
and the amendment shall be filed. Full stop. Once the amendment is filed, the registry shall list the.
My lord, till such time, my lord, now they have started groundwork, my lord. This is the interim order, not to proceed with the.
You supplement the pleading, then you list it. We are only permitting conversion, right?
My lord, even otherwise, my lord, this is the fundamental rights of the even individual will be affected, my lord. Even as a petitioners, individuals will be treated as it will be affected. My lord.
You want to convert or don't?
I will convert it, my lord.
Do it. Supplement the pleading within 1 day and file to get it to listed to.
My lord, next week, my lord.
What's the date?
Cell number 13, PB Vidyulata.
This is a matter where, my lords, on the letter written by the district sessions and district judge, my lords, Mysore, the task force committee, my lords, had withdrawn the approval, my lords. Your lordships had granted an interim order, my lords, which is at page 127.
This is that.
Yes, my lords, the district and sessions judge, Mysore, my lords. Yes, my lords. Yes, please, my lords. The chairman, she writes a letter to the authorities, my lords, in spite of.
Chamarajanagar.
Yes, please. Yes, please.
So today, what is this petition?
This petition is another leaseholder, my lords. Similar thing is, my lords, the task force committee has annexure H1, my lords. Kindly see page 100, my lords. This is the task force committee.
On the basis of this letter,
On the basis of the letter, they withdraw, yes, the recommendation. Please, my lord.
Lease is withdrawn.
No, only the recommendation is withdrawn, and there is a threat, my lords, that the petitioner will not be permitted to continue acquiring, my lords. That's why we are seeking for an interim order, similar to the one
On
granted.
similar matters, my lord, we are not precipitating the issue. Anyway, considering that they have an apprehension, my lord may pass a similar order and post it along with the connected matters.
Great.
Learned advocate, Ms. B.V. Vidyulata. Makes that the impugned order is impugned order reflected in the proceedings of the district task force committee dated 4/11/24. Reflects that the recommendation given by the competent authorities for grant of co-release in favor of the petitioner, which was co-release number 318, has been withdrawn and annulled and withdrawn on the basis of, where is that communication?
Letter of the Honorable Principal District and Session Judge at page 69, my lords, Annexure H.
On the basis of
69, my lords.
letter come communication dated 3/10/24 addressed from one Srimati V.S. Bharti, Principal District and Session Judge, and holding the post of Chairman of District Legal Services Authority, Chamarajnagar. Full stop. It was pointed out by learned advocate for the petitioner that this is at least the third instance, 22 minutes. Third instance.
Fourth instance, my
Fourth
lords.
instance, where the cases of grant or cancellation of the lease to the parties concerned have been influenced, where the decision in respect of the cases for grant or withdrawal of the lease in favor of third parties have been influenced by the very communication.
Yes, please.
Full stop. Learned additional government advocate Ms. Nilofer submitted that the same order may be passed. That in view of the above facts, same order may be passed as was passed in the earlier similar petitions. So, what is that order? Notice.
23rd,
On page,
127, my lords.
129.
127, Annexure L.
Paragraph 7, page 129.
One such similar order is produced on record, which is dated 23rd January 25 in writ petition number 1234 of 2025. Following the said order, paragraph, notice returnable on. Following the said order, comma, notice returnable on. Now vacation, after vacation.
It could, yes, my lords, after vacation. It could kindly be listed along with these petitions.
19th of June.
Please, my lords, any day.
The respondent shall not take any precipitated steps against the petitioner, only relying on the basis of the, only relying on the contents of letter dated 3/10/20. Present petition shall be notified and listed along with the said similar petition number 1234 of 2020.
Great.
Obliged, my lord.
Or say that the said petition number 1234 shall be notified along with the present petition.
Grateful.
Sixth of June. Only 6th of June.
Yes, please.
Other matter is.
Yes, please.
So 14 to 18 are urgent. 19 also.
Regarding matter arising out of the batch of writ appeals challenging the APP charge.
There are 22 petitions listed today, my lords.
So this is that.
Regarding the
Pro rata
APP charges,
Pro rata, BWSSB pro rata
All
charges.
are urgent. That somebody.
Much obliged.
24th of June.
I don't know which
27th
date
of
is-
June.
Which date is this? 27th of June.
That's the main 902, writ appeal 902 of 2020.
702
So this is up to which one?
to 19.
Up to 19.
1945.
And 45. It is already adjourned. Somebody has given the number.
That is like a batch of writ appeals they have mentioned. The other batch of writ appeals, which is also not tagged along with this.
So all shall be. On that day, you will club all together. When it is next.
Similar
Similar-
matter, serial number 48, the interim order may kindly be extended to the next date of hearing.
48. So to be listed with. Delay is there? No.
Delay is not there.
Delay is there?
Delay.
48.
Delay is not there. The
Delay
interim
is
order was
not.
already granted.
1575/24.
1575, indeed.
It shall stand, the appeal shall stand over to the Stand over to, and which date?
27th June.
27 June to be listed along with given in number, connected.
There are similar matters, I'll give the list, maybe connected.
List it on 27 June.
Interim order, your lordship.
Seal number,
Interim order granted earlier shall continue to operate till the next.
seal number 20. To Uday Shankar Rai.
For the complaint, serial number 66 is a connected matter between the parties, my lords.
This is what, number 20? 20. So what is it about?
Serial number 66 is a connected matter between the parties, my lords. Another contempt has been filed by us against the same bank.
My lord, this matter pertains to setting aside of compulsory retirement in a proven.
But he has already retired. So we'll list it here at leisure.
Yes, file
After
the
that.
contempt petition also.
Contempt to be listed on 24th of June.
He may not precipitate contempt.
The serial number 66 may be connected with these
66 to
petitions,
be
my
listed
lords.
with this matter. There shall be no precipitative action by either of the side. Either of the parties.
Seal number 21. Sri Rajsekhar.
Get it listed on 30th June. 30th June.
Seal number 21.
Or the respondent gave it.
My lords, the fifth respondent had informed that they would be seeking time in this matter, my lord.
Who?
Now, fifth respondent, my lords. I don't know if the,
So we keep it on 27th of June.
please, my
To
lords.
be listed on 27th of June.
Seal number 22.
Delay is that delay of 13 days. Notice written on 30th June.
13 days. Delay, my lord, the other side appear.
All are appearing
Appear, my lord.
and is condoned.
Yes, my lord, this is only respondent. Delay can be condoned.
Yes, what is it about?
My lord, there is operative portion of the order is at page number 40, my lord.
Delay is condoned. Delay is not condoned. All learned with respect to all are appearing.
My lord, I appear for the only sole respondent.
Sole respondent.
So for number 1, Satya Grenades, who appears?
I appear for that.
You are the only respondent.
Sole respondent.
All learned with parties, the delay of 13 days is condoned, a sufficient cause is made out. Application is allowed. Appeal shall be listed on after vacation. 20th June.
Seal number 23. Mr. Murugesh V. Charity.
Lakshmi, I'm told that I'm not furnished the complete set of appeal memo. I'll furnish it, Lord. Lordship may have it on next Monday.
What is that urgency?
With the sole respect.
Any contempt is filed?
Yes, contempt is.
So is already listed?
Not contempt is filed, and but the learned single judge has kept the matter for further compliance also. Learned single judge has kept the matter for further compliance.
Learned single judge. This
Yes.
This is interim order.
No, not final order for reporting compliance.
Give copy and we'll keep it on 23rd.
Please.
Seal number 24. Mr. Raghav.
For the appellant in the matter.
Lords, I'm challenging this order of the learned single judge passed on the 12th of February 2025, my lords, which can be found at page number 23, my lords. It's a service dispute. What I'm contending is that the appellant was appointed as a circle-based officer, and as per the terms of training and assessment, he was supposed to have received 6 months of training, my lords. Whereas immediately after 2 months, he has been placed on deputation to a business office. My lords, there is breach of contract by the bank, and he has failed in 2 assessments that were held because of lack of training, my lords. So this is the exact contention taken before the learned single judge. And the
notice returnable on 1st July. Yours shows a termination during probation period.
Termination during probation.
The ground of unsatisfactory service.
Millets, there is a legitimate expectation on part of the appellant, Millets, that has not been met by the bank, because they were supposed to have given the training, Millets. I will show this annexure, Millets. As per their own contract, they were supposed to have granted 6 months of training. They have not granted him. And as a result of that, he has failed in his examination assessment.
Notice is bonus to you.
Number 25,
Much obliged.
state appeal.
Delay
for the respondent.
Delay all are appeared.
Very
Delay
for
of
respondent,
160
appellant
days.
state, my lord.
So who appears for
3 respondents.
only respondent? No, 3 respondents. Private respondents are not appearing.
I was the private party who instituted the writ petition.
No,
I'll have to take out notice, my lord.
so somebody has
only
to
on
serve
one.
this. Krishnappa Ravi Kumar contract.
Yes, my lord. I was the writ petitioner.
But then Chief Election Commissioner,
Let's
notice returnable.
may I make this request. Between the same parties, in respect of the very dispute, another appeal was filed, which your lordships, my lords, have considered, my lords, and passed the final order dismissing, my lords, the writ appeal, my lords.
True, my lords.
May I just place that material under?
That has not gone to Supreme Court.
No, my lords. That has been complied, my lords. Partially complied. No, my lords, these writ.
Lord, that is true, my lord, in respect of the connected matter, my lord. Writ appeal 471, my lord, there's an order of rejection by this honorable court. I will seek instructions, my lord, if an SLP has been preferred in the matter.
They have paid the
condone
amount.
the
I am
delay and
with
have
it.
it next week, my lord, sometime next week. We'll update the court about the status. Because the same order will follow here also, my lord.
When it was stated by learned advocate Mr. Francis Appellant that in the similar case the appeal was allowed.
Appeal was rejected, government state appeal. was
Government's
rejected.
appeal was rejected.
Appeal was dismissed by this court, pursuant to which the order of payment of amount has been partially complied, has been also partially complied with. Full stop. Learned additional government advocate Mr. Harish wanted to take instructions on
Please,
this court. Full stop. In order to enable paragraph, learned additional government to take the necessary instructions. Stand over to 22nd, 23rd,
Some more time, my lord, just
29.
before the vacation, my lord, sir.
29th,
Please.
29th of.
Very well. There are other connected appeals, my lords. Can I just pass on the numbers?
How many?
There were 7, my lords, altogether. 1 is dismissed, 6, 1 is before your lordships. Remaining 5 are in the register.
Then they would certainly be referred.
My lord, lordship may condone the delay, my lord. If that is the case, all appeals may be listed
No,
together.
take instruction first.
Very well, my lord.
Very well.
Going to comply with or you?
Very well.
Very well. Great.
All those can be listed on that day.
Please. So,
Or better you give number to the council.
yes, ma'am. I'll pass on to the court officer also. I'll give it to my learned friend also.
That's it. Don't list it, but give number so that.
Very well. Very great.
Number 26, Mr. Satish K. Appear court. Council court.
Who appears? Delays to be condoned.
Delay is not there, my lord, actually. Kindly see, my lord.
Leave to appeal.
There's a direction lot. Passing structure investment, 10 lakh cost also. There are 43 and 44 bullets of the order. Page 50.
Who are you?
Appellant was the special land action officer at that time. He is not a party in individual capacity. He is hired as a SL, special land action officer. Cost 10 lakh is imposed, page 50, and structures are passed. And that cost will be deposited in 4 weeks. Lord.
1 second. Paragraph 43.
Page 43, page 50, para 43.
Why cost is imposed? Why cost is imposed?
According to the award is illegal. I have exercised my power, quasi-judicial power, my lord.
Disputed amount is deposited in the president.
Disputed amount is deposited in the treasury. Page 403, my lord, and see.
Who dispersed the amount?
Lord?
Who dispersed the amount?
Apportionment is made.
Disbursement of the amount is by whom?
Yes, Lord. As a special and action, I have disposed, Lord. I have disposed.
You were there at that time or some other officer was there?
Some other officer was there at that time. I have passed the award, Lord.
The disputed amount is deposited in the treasury. Then one needs to first
How this order affects you?
1/3, 1/3 amount is deposited.
No.
Whatever amount she is claiming.
Paragraph 43 says,
Yes,
Learned Single just said, I am of the view that it would be appropriate to impose 10 lakhs
10 lakh.
on the special land acquisition officer who has permitted the dispersal. Who has permitted dispersal? You were there or not there?
Lord, I have passed the award. I ordered for dispersal also. Afterwards, it is dispersed.
Afterwards?
It is dispersed by some other officer.
Some other officer.
Yes, I have passed the award. I have passed the award. I have portioned the compensation. I have ordered for dispersal also, but I have not dispersed it.
So what is that fine distinction? Order and not disposal.
No, I was not. By the time I was
ordering disbursement is as good as.
No, I was transferred by the time, not actual disbursal. 403. Kindly take note. That amount is deposited in the treasury.
So your successor had no option but to disperse because order you passed.
Successor dispersed them.
You can't say that you are not dispersed.
Yes, I cannot. My lord is right.
Passing order of disbursement in such a manner is more serious than actual disbursement.
Page 403, my lord, kindly see. 1/3 amount is deposited. I have not disputed amount is not deposited.
You are against cost only?
Cost. Kindly see the prayer also. I have not said anything else. Only to the extent of cost and
IA number. This is his serial number. 26, IA number 1 of 25. You are in personal capacity?
Yes. Yes, my lord, because I have no other go. I'm not a personal capacity, I'm not a party, but that's why I'm seeking leave of this court.
You are not a party?
No, my lord, I'm not a party in personal capacity.
No. You are a party or not?
I'm a party in the official capacity.
Cost is not imposed on personal capacity.
But this is SLO who pass an order should be paid. Should pay the amount.
The present application is filed. Heard learned of the parties. The present respective parties. The present application is filed by one Sri L. Bhima Nayak, NAIK, who holds the office of Special Land Acquisition Officer. Original respondent number 4. Paragraph. The applicant herein seeks to challenge judgment in order dated 3rd February 2025 passed by a single judge in the writ petition number 28743 of 2023. The present application appears to be in personal capacity. Since filed by name, paragraph. The applicant is aggrieved by the said judgment and order, more particularly in respect of direction contained in paragraph 43 of the order of learned single judge, in which it is observed as under page 43 quote karna hai, full stop. In the facts of the case, the applicant has interest in the subject matter since the above direction operates against him. In that view, the leave to appeal deserves to be granted. It is granted, the application is allowed. So, you are the only respondent?
1 and 5, my lords, there are many.
So, what about rest?
There is a BMRCL which has the panel counsel, my lords. 2, 3 and 4 have the panel counsel, my lords. And the others are the private respondents.
Then we have to also notice, no order, notice in IA number 1 of 25 as well as in IA number 2 of 25, IA number 1 of 25, as well as in IA number 3 of 25, including there shall be notice in the main writ appeal, returnable on 10th of June.
Stay of that blood cost. 4 weeks I have to deposit, otherwise blood.
Grant stay, will incline to grant stay, but after condonation of delay.
But otherwise, blood, I'm liable to, within 4 weeks I have deposited. No. Kindly see, my lord, learned judge monitoring this proceedings. Kindly see page 58, lord.
But Mr. Only thing that delay is not condoned, we can't pass any.
But 2 days delay is not there, lord. I explained it also. Kindly take 58 lord, for a moment. I leave it to the court till my lord feels that I have nothing to say. Page 58, lord, learned judge is monitoring the payment of cost, lord. Kindly see. Page 58, para 67. Read the matter on 3325 for the state SLO to report compliance. Then, my lord, it is hereby made it clear the order would not preclude the state to recover the loss sustained by it from the concerned officer, including the present SLAO who permitted the dispersal, who has chosen to represent himself through the so and so. State shall also entitled to initiate disciplinary proceeding against all officers concerned who are responsible for the absolutely so and so manner.
Any contempt.
I'm not a personal party also. I can understand.
But we'll consider your request, but after the delay is condoned.
Delay condition, no delay. Office has raised it.
Then the endorsement on the board by listing the present appeal and the other connected interim application indicates that there is a delay of 2 days in filing the appeal. Full stop. Learned advocate Mr. submits that there is no delay in facts of the case. In view of this submission, let the aspect of delay be examined by the Register Judicial and the report be submitted, put up on 23rd of June. If there is no delay according to Register Judicial, we'll say that we'll proceed with the matter.
Notice, blood, other respondents are concerned, blood, because it will take.
They're asking Register Judicial to examine whether there is a delay or not in view of your submission and listing the matter on 23rd. If the registrar judicial says there is no delay, we'll proceed with the.
My lord, may dispense the service of the notice of others response.
We are not issuing notice, Mr. Counsel.
Right.
Yes.
So number 27, Mr. Nandish Patil.
Right.
Lord, appellant, my lord, is a bank. Respondent, my lord, is the borrower. My lord, the loan account of the respondent, my lord, became NPA in 2016. We initiated SARFAESI proceedings, my lord, and sale notice was also published. My lord, the sale, my lord, one of the successful bidders, my lord, has deposited the entire sale consideration. The learned single judge, my lord, if your lordship sees page 12, my lord, has entertained the writ petition, and my lord has proceeded to stay the confirmation of sale also, my lord.
Where is the order?
My lord, page 12, please, my lord. Lord, there are three orders, my lord. If your lordship sees the third in number, my lord, dated 31/12/2024. Though the auction sale shall go on, respondent by then shall be restrained from confirming the auction sale till the next date of hearing. Now, my difficulty is, my lord, the successful bidder has deposited the entire amount, my lord. But still, my lord, the learned single judge.
Who is the petitioner before learned single judge?
My lord, the respondent herein, my lord, that's the borrower. Please.
Why should we go before learned single judge?
Lord, my request is only this, my lord, your lordships may permit us to confirm the sale, my lord. Otherwise, my lord, the successful bidder, my lord, we have brought it to the notice of the learned single judge also. If your lordship sees, my lord, the order dated, my lord, order dated 19/2/25, my lord.
Yes. What amount is deposited by the borrower?
My lord, the successful bidder has deposited 1,81 lakhs, my lord.
That's correct.
Please, my lord. Subsequent to the direction issued by the learned single judge, my lord, the borrower has also deposited 25%. But my submission to your lordship is, my lord, the writ itself is not maintainable. And in fact, my lord, post the amendment,
Not. We fix the time limit.
and the successful bidder, my lord, has deposited the amount on 21/1/2025, much earlier to the order of the single judge.
Heard learned advocate Mr. So and so for the. We're not entertaining appellant, but we will at least request learned single to take up the main matter and raise your all contentions, including maintainability.
Lord,
For the appellant bank. The challenge is sought to be raised in this writ appeal by the appellant against order dated 28/2/25, passed in the pending writ petition number 35709 of 2024. In the original, in the main petition filed by the respondent hearing, what was challenged? What is challenged?
A sale notice was challenged.
Appellant bank supposed to be an auction sale notice dated 2/12/24, whereby the auction sale was fixed on 7/1/25. Also, the auction was held and was to be conducted pursuant to the action taken by the appellant bank under the SARFAESI Act 2002, Purana, in respect to the property in question. Proceeding against the petitioner for non-payment of the dues of the bank. Full stop. As per the impugned order. It appears that in the auction, the sale was confirmed at rupees 1.81 crores. Full stop. As per the impugned order. Passed at the interim stage, learned single judge as per the impugned order in the petition which is filed by the borrower, learned single judge observed that the purchaser deposited the entire sale consideration of 1 crore 81 lakhs. Full stop. The interim direction of not confirming or direct requiring the bank not to confirm the sale was passed, and the petitioner was put to condition to deposit 25% of which is 1 crore 81 lakhs. Full stop. Learned advocate for the appellant bank would submitted that the bank cannot be prevented from confirming the sale when the auction has taken place and the successful bidder has also deposited the amount. Full stop. It was submitted that the writ petition itself was not maintainable. Any of the alternative remedies available to the petitioner borrower under section 17 of the Act. Full stop. When the main petition is pending and the order is interim in nature, it cannot be said that the rights of any of the parties have been finally decided by a single judge. Full stop. Since the petition is yet to be heard finally, and there is no dripping of finality in the impugned order, the court is not inclined to exercise its appellate jurisdiction. Full stop. All the contentions of the appellate bank as well as of the respondent are kept open to be raised before any single judge. Full stop. It is expected that a single judge shall take up the writ petition on the next date of hearing with cooperation of parties and shall dispose of the same as expeditiously as possible. So this court has not gone into merits of the case of the either side in respect of any aspect. The appeal is not entertained for the above limited ground of it being directed against interim order. On the ground that it is directed against interim order. Next.
This is number 28, Mr. Sampath A.
Lord, appear for the, before I take your lordship to the merits, my lord, I must point out that there's an application for condonation of delay. So therefore, notice has to be ordered if your lordship thinks it appropriate.
11th June.
Notice on the IAM. Great.
Yes, both notice in all.
On all. Great.
Notice. Third learned senior counsel Mr. K.G. Raghavan, the notice in interim application for condonation of delay as well as interim application for stay as also in the return.
Great.
Returnable.
This is number 29, Mr. Deepak.
But this also, there's a delay a lot of 18 days. Only thing is,
If all are appearing, then we can condone. If anybody is not appearing, then obviously notice.
Respondent number 5.
Private party.
R4 private party is on KVA. R5 should come out.
You are for?
1, 2, 3.
For R5 notices to go.
can I seek an emergent notice, Mano?
Mr.
Emergent.
Uday Holla for the applicant. There shall be notice to the respondents in interim application for condonation of delay of 18 days, comma, in IN number 2 of 25 for stay, as well as in the writ of it, returnable on 13th of June. Learned edition government advocate, Mr. So and so and so, Chandrasekhar, accepts notice on behalf of 1 2 3, whereas learned advocate
Respond number 4, my lords.
accepts notice on behalf of number 4. The rest of the respondents will be served.
So commercial appeals, seal number 30, Mr. Shrikara PK.
I appear for respondent number 2. I seek for a week's time to file my reply, my lord.
So what is the challenge?
My lord, what has happened is they have put, my lord, defamatory content, my lord, the respondents have put up defamatory contents. We asked for deletion. My lord, we filed a petition, suit. The learned single judge, the learned commercial court, my lord, says it has to be deleted. But then, my lord, thereafter, my lord, one more, my lord, similar URLs are being put. What the learned single judge, my lord, commercial court judge says is, every time, my lord, even if it is similar, I'll have to, my lord, file an application, advance the case. My lord, it will be, there are 4 judgments of the Honorable, my lord, Delhi High Court, where their lordships have said if it is similar contents are there, they'll have to, my lord, remove it. That's a short question for my lord's consideration. You have to remove it. My lord, what happens is there are, my lord, this Facebook and all of them, Google and others.
Is identically similar or similar or identical?
Identical, my lord, or similar, my lord, same thing, my lord. What happens is, my lord, we are, my lord, selling what is known as Ashirvad Atta, wheat. Everybody, my lord, virtually, my lord, 60% of all of us use that. They are saying it's all plastic, this, that, and all that. My lord, we put at least, my lord, 20, my lord, reports of, my lord, FSA, everybody. And, my lord, the learned judge says, I'm bound by one judgment of learned single judge in this honorable court, where he has said that every time you will have to go to the court. My lord, what will happen is the commercial court, my lord, every time, my lord, if it keeps coming up, every day, my lord, there will be applications after applications, advancement. Thereafter, my lord, it will have to be posted. Then, my lord, an application for
70 is the order. It is in your favor.
Please, my lord.
It is in your favor.
Sorry, I didn't get you, lord.
The order is in your favor.
My lord, order is not in my favor, my lord. What has happened is, he says, learned commercial court judge says, every time I'll have to, my lord, make an application.
Let us see where is that.
Please come to, my lord, running page 71, my lord.
Yes.
It is held that the written statement of so-and-so is filed as taken on record. Temporary injunction as paid in IA2 is partly granted only against defendant number 1, and defendant number 1 is directed to remove, take down, delete defamatory content published by defendant number 1 on the social media platform, Instagram, operated by defendant number 2, as detailed in suit schedule, including any upload, reshare, variation thereof during the pendency of the suit. Additionally, defendant number 1 is directed to take down, disable, delete any further defamatory content in relation to the plaintiff's registered trademarks or products.
So you are against the clause number 3 only.
Yes, my lord, absolutely. Every time, my lord, if it will be, my lord, the courts will be flooded, my lord, with.
I appear for respondent number 2, my lord.
It is vacated. The interim order is vacated. Vacated. Why?
Well, there was a blanket order against me also. I'm an intermediary. I won't be able to do proactive monitoring. Only if the plaintiff identify those links, I will be able to action it based on
Lord,
reports.
I have no problem, my lord. I will, my lord, identify and tell him. He says, I'll have to get a court order. That
identify what?
The URL, my lord. That is that.
What is the
defamatory content?
What is URL? URL means?
It's the
Uniform
link, my lord.
resource locator, your lordship. URL is a uniform resource locator, which is the
We'll have to click on
address
it,
for
and
every.
then, my lord, people.
But then every URL might give a first cause of action.
My lord,
Lordship, if
I
your
have no
lordship
problem.
permit,
If, my lord,
what the
what
issue
has
is.
been done by the Delhi High Court is, every time, my lord, if they put up, somebody puts it up, similar, identical, we inform them. If they still have a doubt, then, my lord, they will say, you can go to court. Here, my lord, for every time, my lord, if you have to, my lord, even if a
No, no,
URL,
lordship,
same
we are
URL
okay
is
with
put up
that.
again.
We are okay with that, your lordships. We are absolutely okay with that. As long as there's identical content and there's a court order, the plaintiff can escalate. If it is not covered, we will write to them, then they can approach the court. We have no difficulty with that.
My lord, what happened?
So you only want a verification
Yes, my lord.
that in respect of URL, which may be subsequently, which may appear.
Yes, which are similar to, my lord.
Not similar, lordship, identical. It has to be identical. The
My lord,
underlying suit, the underlying
I think my
content of the
learned friend
suit.
will have some patience, if he doesn't mind.
That will take
I'm
care
so
of
sorry, your
identical
lordship.
thing.
My lord,
You would intimate them, and if they
correct.
don't. and
Similar, my lord, also, my lord. What happens? Let me tell
If
you,
they
lord.
don't remove, then what?
They'll have to remove them.
Then you have to fire if they don't remove.
My lord, what happens is, when the court order, my lord, is there, my lord, they are bound to remove it.
But then
That's, my
every
lord, the
time-
order passed.
Every time question will arise, it is identical or similar.
My lord, can I put it this manner? Subject to my being corrected by your lordships. Delhi High Court, my lord, can I pass on, my lord, two judgments of the Delhi High Court for your lordships?
Lordship, I can cut the controversy if my friend can just, I can explain and help the court. I will just help him if my friend permits me.
Let us see. We'll hear.
I will help him because I don't have a problem. See, when I say similar, and lordship can clarify. What I'm only concerned with is that the underlying content of the suit, sometimes what happens is it is substantially similar. So lordships may say the impugned content, as long as it is the impugned content, they escalate to us, we will take down. And if it is not, then they can come and approach the court. So therefore, the question of identical and similar does not arise. Your lordships can say impugned content.
Please come to, my lord. Can I persuade your lordships, my lord? Just look at one detailed judgment, my lord, of the Delhi High Court at page 18, my lord. 1A. This, my lord, please come to, my lord, page 100 and paragraph 112. At, my lord, running page 100 and, my lord, running page 66, my lord, 66. My lord. Under these circumstances, the following directions are issued to the platforms. Defendants are directed to take down, remove, block, restrict, disable access on a global basis to all such videos, web links, URLs in the list annexed to the plain, which have been uploaded from IP addresses in India. Insofar as URL and links in the list annexed to the plaint which were uploaded from outside India is concerned, defendants are directed to block access and disable them from being viewed in the Indian domain and ensure that the users in India are unable to access the same. Upon the plaintiffs discovering that any further URLs contain defamatory or offending content as discussed in the present order, plaintiff shall notify the platforms which will then take down or block access to the said URLs either on global basis or on Indian domain, depending on whether contents have been uploaded in terms of 1 and 2 above. If the defendant platforms, upon receiving notice from the plaintiffs, are of the opinion that the material content is not defamatory or violative, they shall intimate the plaintiff and the plaintiff should seek remedies in accordance with law. Then I will have to move the court. Similar order, my lord, if it is passed, my lord, I'm satisfied.
Lordship, I have an objection to that. So I'll file a reply to this because today what my friend is saying, and see the issue of global blocking is pending before the Delhi High Court. I am happy taking down similar content, which is the subject matter of the suit. But as far as the issue of global blocking is concerned, I will have to put a reply on that. I can't do things globally because that is the standard of defamation, and other standards are territorial in nature, and the IT Act does not apply globally. So to that extent, if my friend is pushing for a global takedown, then I will file a reply. But as long as it is the same content, we can take it down, geo-block it, and action in India. So lordships may permit me to file a reply to this, and lordships can fix a short date for this. I will argue this matter then.
Can I submit this? Global content, my lord, your lords may not give me that order. The rest of, my lord, the order, my lord, your lordships may give. If it
Then
is
I have no
agreeable.
difficulty. As long as your lordship say the underlying
Only that
improved
global content,
is
my lord, your lords may remove it.
Which global content?
What happens is,
Now, whatever is discussed in the judgment and the URL is referable to that content, this will apply.
yes,
That is what the directions are.
correct. Only thing is, my lord, what has happened is, somebody in America, my lord, may access it. So global content is, that also should block. That is what the Delhi High Court has held. So my learned friend has some, I'll come to it. My learned friend has some objection with regard to global content. Your lords may, my lord, remove that global content. Say that, my lord, if there is, they will remove the access in Indian domain.
Yes, your lordship. That we are fine with.
Please come to, my lord, number 3 at page 67. Sorry, number 1, sorry, page 112.
Only number 1 it global.
Number 1
word
global,
figures.
and then 3 also there's a global. So, my lord, that global, this thing your lords may remove. Rest of the things, my lord, can be there.
As long as your lordships are saying in the Indian domain, I have no difficulty. Lordships may
Very well.
may not
That
know
global, word
we will do
global
it
may
as
be
long as it
removed.
is identical underlying content of the suit. That we will take down.
So to all such videos, web links, URLs.
Correct.
At the domestic level, by the domestic level operators.
Correct.
Will that say that?
Yes. Only word, my lord, global, if it is taken
That
out, my
will-
lord,
that
the rest
will-
of it, my learned friend is agreeable, I think. Very well.
Yes,
Please
sir.
do that. 1 and 3, the global, my lord, may be removed. Rest, my lord, would be all.
Will say that all such videos, etc.
Yes, ma'am.
by domestic level operators.
Correct.
Will
In the
it do-
Indian
Lordship
domain, my
will
lord.
use the phrase, the correct phrase,
Or-
geo-block. We'll
in-
geo-block it.
In the Indian domain, domestic level operators in Indian domain.
Please.
Yes, your lordships.
So this can be disposed of.
Please, my lord. Grateful.
Yes, so get
Yes, your
the,
lordships.
we'll pass the orders.
Very well.
Lordships may just give me liberty if it is not the subject matter of the suit, then I will tell them and then they can approach the court. That's
So
the
what
only
did you
liberty.
say? At Indian
Domain, my lord.
Indian domain. Yes, Mr. Votair saying.
Lordships, the only thing is because if the content is not pertaining to the suit, in that case, your lordships may give me liberty to tell them, then they can approach the court.
All right, my lord, suit doesn't get disposed of. This is only IA. Suit, my lord, remains as it is in the.
The appeal is disposed of.
That's right.
So all contentions otherwise open.
Please, my
issues
lord.
are open.
Grateful to you.
Yes, your lordship.
So what about if there is a dispute about similarity?
My lord, that 4th paragraph, my lord, takes care of it, my lord. Please look at, my lord, para 4.
Correct.
If the defendant platform, upon receiving notice from the plaintiff that the opinion material content is not defamatory or violated, they shall intimate the plaintiff. Plaintiff should seek remedies in accordance with law. Therefore, we will have to go to court at that time.
This is fine, your lordships.
Correct.
So any such dispute which is falling under 4 may be dealt with in the suit.
My lord,
Yes.
similar order if it is passed. Same, my lord.
We are
As
fine
it
with
is,
that,
my
your
lord,
lordship.
4,
It means
except
that-
removing the global, my lord. If your lord says remove the global and the.
means that.
Please, my lord. Grateful to your lord.
So
Grateful,
just
your
go
lordships.
through,
Please.
go through our order on day after tomorrow.
Grateful.
Grateful, your lordships.
Thereafter we'll upload it.
31.
So disposed of. Yes.
30 and 31, both, my lord.
Both.
Please.
Both are identical
Yes.
from different suits.
My lord, what happened is same. We filed an application. They filed, my lord, we got an interim order. They filed an application of vacating. Therefore, my lord, it is.
Cross.
Yes. Please.
So get the appearance. Appeared online.
Case number 32, Mr. Padmanabh Holla.
Preparing for appellant in this appeal appeal against the commercial AP 330 of 23. Issue is land acquisition of the NHI, enhancement of the compensation of the arbitrator and DC.
Well, notice written on
Much of it.
2nd July.
Case number 33, Mr. Raghavendra K.
defendant's appeal, ma'am. Suit for ejection. I'm running a commercial establishment, ma'am. There is no dispute between the relationship of the party. It is a landlord and tenant. And also, my lord, it is not in dispute that the agreement entered into between the parties would expire or come to an end the end of 2025, month, the December 2025. Not this suit came to be filed.
So you say notice,
Please, not.
notice, notice.
Lord, I have sought for a stay, not that they have filed a.
Deposit the amount.
I'll deposit, not insofar as the, in both the cases, not it comes to around only 3 months rent I have not paid. That's the allegation. I'll deposit, man.
Decretal amount entire 5,71,120 and 1,46,000.
Lord, the dispute between the parties, not only for a period of 3 months. My lord, may kindly have a look at in page 37 for a moment, not. That amount I will deposit, man.
That will go into, but whatever is directed is a money decree.
Lord, the total amount comes to 13,95,350, man. That I will deposit, man. The disputed amount I will deposit. At in page 37, man. Both the cases, my lord, it is one, the serial number 33 and 34 goes together, my lord. In both the cases, my lord, total amounts comes to 13,95,350, my lord.
So 33. Heard learned advocate Mr. So-and-so for the appellant. In the text of the case, there should be notice returnable on 14th July. Full stop. Learned advocate for the appellant prays for stay. The judgment in order of learned testicle judge allowing the suit is a money decree. In that view, the stay cannot be granted unless the condition of deposit of the decreed amount is observed by the appellant. In that view, there shall be stay of given judgment and order on condition that applicant deposits the entire decreed amount with the registry of this court on or before 1st July.
Yes.
If the amount is not deposited, the stay shall get
Within 2 weeks, no? Within 2 weeks, sir.
on or 1st July.
Yes. Great.
Shall get automatically vacated. Same order in next matter.
Yes.
Seal number 35, Mr. Mohammed Shamir.
I here for the appellant in this matter. The commercial appeal challenging an order passed not by the commercial court rejecting a plaint on the ground, Lord, that the charity commissioner's permission under the Maharashtra Public Trust Act had to be obtained prior to filing the suit. The transaction, Lord, between the parties is, my lord, a transaction simpliciter of a contract, in terms of which they were permitted to utilize a mark called IEEE. The court, my lord, recognizes the law and then says, because you're a company, therefore you must take the permission of the charity commissioner. And my lord, I had the benefit of an interim order against them, restraining them from using my trademark. And now that interim order is gone.
You are the appellant?
Yes, my lord, I am the appellant plaintiff. I am the plaintiff. Plaintiff. There is a contract, my lord, between the plaintiff and the defendant. In terms of the contract, my lord, various things had to be done. One of the things was I had allowed them to utilize a brand called IEEE. And then the contract was terminated by us. They continued to use the brand. Therefore, my lord, we filed a suit for an injunction to restrain them from utilizing the brand.
So there is a termination notice by them.
By us.
By
We
you.
terminated, my lord, the contract because of various violations. We said there is a breach.
What is the relief in this suit?
My lord, the relief in the suit, my lord, please take, my lord, page
114.
114, my lord. Declaring that the service assistance agreement dated 29th August 2012 and 1st April 2013 executed between the plaintiff and defendant stand duly terminated in light of the notice of termination dated 2nd May 2024 issued by the plaintiff. Second, granting an order of permanent injunction restraining defendant by themselves or the agent so and so from using in any form of manner the IEEE brand, mark or name or using the essential and or salient features of the registered trademark of the Institute of Electrical and Electronics Engineers or any other mark.
What was the service assistant agreement as such?
Lord, that may I just hand over the document, Lord? Lordship may kindly see. It's an agreement, Lord, whereby we were to give them some assistance in respect. This is an institution of engineers. IEEE is a global institution of engineers, and there are various chapters, Lord. There's an Indian chapter here, which is not the plaintiff. The plaintiff, Lord, then enters into agreements with various other entities in various parts of the country, and Lord, say various assistance is provided. As part of that, Lord, the IEEE brand is permitted to be utilized.
But then what prompted you to file this suit?
They continue to use it after the termination of the agreement.
I started in 1973 before this plaintiff
But that's a
even
different
started.
issue.
The injunction they have sought.
You have an injunction.
The court below said that there is a lack of cause of action.
There is a lack of cause of action,
Doesn't
my lords.
appear to be.
There is a bar under the Trademarks Act because they are not the
That's
registered
not the
trademarks
ground.
owner. That is
not the ground
my lord.
raised. That's not the ground answered by the
Today
judge.
they cannot be given an injunction on this ground, my lord. The trademark is owned by a separate company who is not a party here. In India, there is a registered trademark which they are not the
You
trademark.
said that there is no cause of action.
Because they do not have a cause of action. They cannot sue.
How?
Because the section 53 of the Trademarks Act says a suit can be filed only by the registered owner.
Cause of action is not to be confused with the merit.
As a matter of fact, Lord, my learned friend must point out to the court as to where the learned judges even considered that.
Under Order 7, Rule 11, the bar or suit can be rejected where there is a legal bar to filing a suit, not merely when there is no cause of action. My ground was both that there is a bar under the Maharashtra Act as well as under the Trademarks Act because they are not the registered owners of the trademark. I have been using it since 1973. The 1976. The trademark is registered by a US company, the parent company of this plaintiff. In the year 2000. It has not been assigned to them. They do not own the trademark. They are not registered users. They are merely licensees. And the Act prohibits them from filing a suit. They suppress all of this. They do not produce their trademark registration form. They produce that subsequently. A trademark infringement suit
That
is
argument
filed
is rejected.
without even producing
Lord, I'm
that-
sorry. My learned friend can't argue application for injunction now. As a
Without
matter of
even-
fact, this is an application of rejection of plaint and rejected only on one ground, and that is the charity commissioner's permission is not taken.
In
My
an
learned friend is arguing
infringement
something
suit,
else.
in an infringement suit, they do not even produce the trademark certificate because it is not in their name. It's in the name of a third party who is not even a party here.
think,
And
my
the
lord-
reality is that this suit has been filed for taking over control of this society, which is registered in Bombay, which they cannot do under the the Maharashtra Act.
Ground is only 711.
Two grounds under 711.
The ground is non-obtaining of permission of charity.
That's first ground and trademark.
That is
Kindly see
rejected.
my
That
trademark
argument is
application-
rejected. You didn't file an appeal.
Section 50 of the public.
Yes,
kindly see, Manoj. As I'm also filing objections to their IA, if I may be permitted to tender
Page
that as
75,
well.
Lord, has the learned judge has extracted it, not page 75.
Give me our full compilation.
And Lord, as a matter of fact, I think in Gujarat High Court, Lord, there are any number of judgments now examining the Bombay Trust Act itself and holding that at best this can be an issue. It can never be an application of rejection of plaint. I have placed 3 judgments, my lord. At best, an issue of whether permission of charity commission is required can be an issue. It can never be a ground to reject a plaint. 3 judgments. And my lord, one judgment which considers this identical issue with respect to BCCI and says it is also a society, but you don't need the permission of charity commissioner when you're suing for a personal right. The court, my lord, has confused administration of a trust, which, my lord, is like a suit under section 92 of
I've
the Civil
handed over a
Procedure
copy
Code.
of the Act also. I just saw. Both grounds have been taken by me. The bar under the Maharashtra Public
Lost on
Trust
the
Act
first ground.
and the bar under the Trademarks Act. Because the suit simply, it does not lie in their mouths to file the suit. They do not have the power to file this. They are not a registered owner. They are not the registered user.
My lord, if my learned
And I
friend
have
can
been
point
using
out
it-
that on the
been using
Trademarks
it
Act,
for
the
30
court
years
has,
prior
I
to
think my
that.
learned friend, my lord, should be fair to the court. Can he point out, my lord, that this is the ground on which the plaintiff has been rejected?
For-
And he's arguing that now?
For 30 years prior to their existence, I have been using this trademark.
Please. That is a ground on merits, not on rejection. Page 40, my lord.
You are a public trust.
Please,
Not
Not
as-
I am, my lords. The
They-
defendant is.
You
They
are
are,
a public-
they are a society.
We are registered as a society and registered as, under the Public Trust Act. I've produced both of the registrations with my objections.
Objections.
And they have also pleaded, it's an admitted fact. They have said it in the cause title.
Clause 4, it will not.
No, my lord. As a matter of fact, clause 4 has been held to be relevant only from the point of view of administration of the trust. My lord, ultimately, it's like a section 92 suit, my lord, under the CPC, where, my lord, the public charitable trust, a suit has to be filed. You must file a miscellaneous petition in all of the places. Where the charity commissioner is there, you must make an application before the charity commissioner. He must grant you permission. And that, my lord, is settled legal position. And my lord, lordships will see, it has to be a suit filed by 2 or more persons interested in the trust.
Where is that?
My lord will see after 4, 50, 1, 2, 3, 4.
2 or more persons. having-
2 or more persons having an interest. In case the suit is under subclause 1 to 3, or 1 or more such persons in case the suit is under clause 4, having obtained the consent in writing. Therefore, my lord, one can say no suit against a trust can ever be filed by a third party if this is the interpretation that is taken as has been done by the learned.
Section 50 deals with persons who are interested.
think
Section 51
Don't-
deals with persons who are not interested. If you do not have an interest in the
Yes,
society,
one or more
then
such
only the
persons.
charity commissioner can file a suit. Persons who have no interest cannot even file this suit. And in their paras 4, 5, 7, 8, 10, they have set out in detail how they are interested in my society. They check my accounts. They decide how much I spend. They decide my budget.
My learned friends'
Their
defense is
entire
becoming this
pleadings are
application.
about how interested they are in my society. Now they say they are not persons interested.
Lord, I'll show your lordships a direct judgment of the Supreme Court, my lord, which answers this question itself. And the learned judge accepts it on law, but misconstrues it on facts. And all that my learned friend is arguing is his defense, not an application for rejection of plaint.
So learned single judge has pronounced the merits of section 50.
Commercial court.
Sorry, commercial court.
Yes.
So it has gone to the working of section 50.
Which
It
is
said that suit is.
actually, my lord, if your lordship sees
it
the
is
order,
liable to be rejected.
my lord, lordship may see the order. I'll only show 2 paragraphs. Lordship accepts the commercial court accepts the position in law and then misconstrues the relief. I'll just show 2 paragraphs, my lord, in the order itself. Please see the
Sorry,
order, my lord.
Since your lordship
So
is
one
on the
minute.
act, just want to
My lord,
finish. Section
I
80
don't
may
know.
also kindly be seen,
One by
which is
one.
the bar.
One by one, let us.
Please,
I-
section 80 is the bar. I just wanted to point.
One by one, we'll see.
Please, Vance. My apologies.
Lord, may I humbly request my lords to kindly come to page 84, my lord. Para 14. After looking at the entire law on this point, may I just read that very quickly, my lord? 84. I have carefully gone through the above citations. In the first decision, the facts were such that with respect to seeking a right to be a hereditary archaka in a temple and a share in the offerings made to the deity, a suit in relation to personal or private right to the archaka would become a suit in the nature of exercising public right in a public trust. The facts were such that the plaintiff was seeking declaration of his right as hereditary in performing the puja of the deity and also to have his share in the offerings of the deity. In those circumstances, Honorable Apex Court has observed it is a personal private right of the plaintiff which has got nothing to do with the working and administration of the trust or the temple. Therefore, it has been held that the provision section 50 and 51 of the Maharashtra Public Trust Act or Bombay Public Trust Act is not applicable. In the second decision, the issue before the Honorable Bombay High Court was that the plaintiff was seeking declaration of his title over the suit property and for a perpetual injunction. The property in question was not the trust property, that it was an independent property on which the plaintiff was ascertaining his title and so the defendant trust. Bombay High Court, taking into consideration that the subject matter issue is the private right of the individual, observed that consent of the Charity Commission is not warranted. I'm sorry, my lord has 84, my lord.
Where you are reading?
I was reading, my lord, page.
Yeah, Bombay High Court was that the plaintiff was seeking.
Was seeking declaration of his title over the suit property and for a perpetual injunction. Property in question was not the trust property, and it was an independent property on which the plaintiff was ascertaining his title and so the defendant trust. The Honorable Bombay High Court, taking into consideration that the subject matter in issue is the private right of the individual, observed that consent of the Charity Commission is not warranted. In the third decision, the issue before the Honorable High Court was a trust having filed a suit against the defendant to declare the lease deed as null and void and not binding on the trust. Again, in the suit, the subject matter was the private right of the defendant as tenant under the lease with respect to the trust property of which lease was executed by some individual, which was sought to be declared as not binding on the trust. Such is not the circumstance in the case in hand. In the present case, it is the allegation of the plaintiff, defendant association had made use of the mark IEEE, knowing fully well it is owned by the plaintiff and has continued its breach even in the existence of an interim order. Specific allegations that trustees of the defendant trust are making illegal use of the trade name IEEE by infringing the said trademark, causing wrongful loss to the plaintiff, and also the plaintiff is seeking damages to be paid by the trust or the defendant association for having infringed the trademark owned by him. Though the plaintiff has claimed that it owns the trademark, the relief sought against the defendant is to restrain the defendant public trust from using the trademark, also to direct the defendant public trust to pay damages for infringing the plaintiff trademark, and it cannot be termed as a private or individual right of the plaintiff. A right not to a trademark is an individual right. The plaintiff is not a single individual, but it is a private limited company under the name Global IEE Institute for Engineers. It is the institutional right which has been canvassed in the present proceedings, and it cannot be termed as a personal or private right of the plaintiff. In the decisions relied upon, the learned counsel of plaintiff cited supra, the private right of the individual was the subject matter of the right with suit with respect to which, having observed that no public right was involved, the requirement of written consent by the Charity Commission was not required. On the other hand, in the present case, there is no individual rights assigned to the defendant, but the allegation is that the members of the trust, which includes many persons, who have continued to infringe the alleged trademark of the plaintiff. Therefore, for the suit of this nature, prior written consent by the Charity Commissioner, as contemplated under 51, is mandatory, without which the suit is plaintiff is liable to be rejected. The ground, my lord, which is rejected is this. On the ground.
But then what interim injunction can be granted to?
I had an interim injunction. Please, you wish to argue first?
No, sir, please go ahead.
May I just conclude? Lord, may I just pass on, Lord?
Keep that ready to
The injunction order, which was granted, Lord, in July of 24 and continued, and they violated the order. There's a contempt proceeding pending against them.
What is
Give them also, no? Can I humbly request, my lord, to come to page 42, my lord? This injunction order continued to exist right till the rejection of the plaint. 4724, page 42. The relevant portion, Lord, is at page number 45. The order which was passed, Lord. No, I think make it 45 minutes.
But when the final order passed, this is automatically vacated.
Because of the rejection of the plaint, my order went. Now, today, my lord, if that order is, in my humble submission, completely incorrect, I'm, of course, it's a different matter. They violated this order. We filed a contempt application. They never filed an application to vacate the interim order. They simply filed an application to reject the plaint. And then, Lord, the suit is dismissed, owing to which my injunction is gone. And they continue to violate this. This issue, my lord, as a matter of fact, has been fully answered in the Yes, my lord. Lordship may kindly take my petition itself. In the petition, I produced those judgments which I had placed before the court. Can I humbly request my lord to come to page 181?
Memo of citation.
No, my lord, it's there in the appeal memo itself, because along with our written submissions, we had filed the judgments. Page 181 on section 50 and 51 itself. May I humbly request my lord to come to page 189. It starts at 181 at 189. Para 13, my lord. My lord's got para 13, 189. What is to be seen is the relief the plaintiffs are seeking from the court. First of all, they are seeking a declaration about their hereditary right as archaks of the temple. The right is claimed in their personal capacity as a family of archaks who have been performing the function of archaks since the day the temple was established and the deity was consecrated. It is a different matter whether ultimately the plaintiff's contention is accepted by the court or not. Surely the plaintiffs are entitled to have their claim examined by the court. If they fail to examine their claim, they will be out of the court. I'm sorry.
Yes.
189, my lord.
Yes, it is.
So sorry. In the middle of that para 13, however, if they succeed in establishing that claim, they will be entitled to the declaration sought. They cannot be non-suited as a threshold unless a suit is barred by any statute. We have seen the provision of section 50 of the Bombay Trust Act relied upon by the appellant's defendants. Said section does not cover a suit of the present type. Analogy has been drawn to section 92 of the Code of Civil Procedure while considering section 50 of the Bombay Trust Act. Both provisions are in the nature of representative suits. Both provisions are in the nature of representative suits which pertain to public trust and protection of public interest in the trust. In the present case, there is no public interest involved. The only interest is that of the plaintiffs and their families. The right of the archakship is claimed on the basis of inheritance.
Where is your relief in this?
My lord, my relief, my lord, is 140, 114, 114. This service agreement is a bilateral agreement only between the two of us. 114.
That we see. Okay.
Service assistance agreement. And for an injunction to restrain them from using the mark IEEE. This is not a suit in a representative capacity. I am not interested in the administration of the trust. My reliefs, my lord, my suit can be judged on the basis of my reliefs.
So here this final.
Yes, but your lordship may protect me, my lord.
So far as interim relief is concerned, I have two submissions to make. They are not the registered owner. They have not they have suppressed this from the honorable court when the ex parte order was granted. Nowhere is there any explanation in the honorable court's ex parte order, which was passed 8 months ago, which they dragged for 8 months before the commercial court. They obtained this ex parte order without clarifying to the court that it is not even their trademark. They do not produce the trademark certificate either before the commercial court or even before this honorable court. I am producing it now along with my statement of objections to show it is not them that owns the trademark. It is a different company who is not even a party to the suit. And with the bar under section 53 of the Trademarks Act, no injunction ought to be granted to them at all because the suit itself is not maintainable at their hands. May I be permitted to file my objections, Manoj? This is only to the IA1 seeking an injunction. I'm producing all of the documents that were not produced along with the COMAP. 2 sets, 2 volumes.
I don't think my learned friend can argue the application for injunction, my lord. The guys have argued an application for rejection of claim.
Statement of objections to the main appeal.
To the
only to their IA
application.
Before I go there, my learned friend today says I am not interested in the administration of the society at all. This is merely an agreement, a suit relating to an agreement. Kindly take their commercial appeal, the pleadings in their own suit, page 94. Page 94 of the COMAP. As these are, all of these bodies are professional bodies that are created for the larger welfare of electrical and electronic engineers around the world. There's an IEEE organization called IEEE Inc., which is incorporated in the US. 1976, the defendant society began operations in India. This is all set out in their plaint. Kindly see para 7 at page 95. Starting from, sorry, para 5. Page 95 of the COMAP, the commercial appeal memorandum. I'm reading from their plaint. The plaint itself starts at page 93. At page 93, the plaint starts. And in the cause title itself, they have mentioned IEEE Mumbai Section Welfare Association, registered society and a registered public trust under the Maharashtra Public Trusts Act. Para 4, the plaintiff is a second-tier subsidiary partially owned by IEEE Asia Pacific Limited and IEEE Worldwide Limited, both of which are wholly owned by the Institute of Electrical and Electronics Engineers Incorporated. Then para 5, IEEE is the world's largest professional organization dedicated to foster technological innovation. This is at page 95. Then paragraph 7, on 13 July 1976, the defendant was established as a geographical unit of IEEE, which is the US company. Then paragraph 8, subsequently the defendant was registered as a society.
Yes. Now, which is the decision you relied on?
Yes, ma'am. Page note 189.
Missed it. 180?
189, it
Sorry,
starts
in the appeal memo.
in the appeal memo itself, it starts at 181
Correct.
at 189.
Yes.
Please, the paragraph 135. Paragraph 38 at page 106. In this context, it is relevant to note that IEEE Inc. is the registered proprietor of the following trademark, IEEE trademark, as set out in the schedule to the plaint. Paragraph 39 at page 107. In their plaint, they say, in terms of Schedule A of the agreements, IEEE has licensed the use of its brand and named to the plaintiff under a licensing agreement dated 29th August 2012. Even this licensing agreement under which they claim to have a license is not produced before the commercial court along with their plaint. So they don't produce their license agreement. They don't produce the trademark registration, which was licensed to them according to them. And yet they are granted an ex parte order, which they then drag on for 8 months in a suit which is not maintainable.
Yes.
Then last two points, Section 52 and 53 of the Trademarks Act, if I may kindly be permitted to read. Section 52, right of registered user to take proceedings against infringement. Subject to agreement existing between the parties, a registered user may institute proceedings for infringement in his own name as if he were the registered proprietor, making the registered proprietor a defendant and the rights and obligations of such registered user in such case being concurrent with those of the registered proprietor. Then kindly see 53. They are not the registered user. There is no registered user agreement between them. They have no registration in their name. 53. No right of permitted user. This is what they claim to be, though they have, as I said, they have not even produced that agreement. No right of permitted user to take proceedings against infringement. A person referred to in subclause 2 of clause R of section 1 of section 2 shall have no right to institute any proceeding for any infringement. That section, definition section, your lordship may kindly see, is subsection R of subsection 1 of section 2 definitions. Clause R, my lords, would have two subsections. The first subsection of clause R refers to registered users. Permitted use in relation to a registered mark means the use of a trademark won by a registered user. They are not a registered user and they do not claim to be a registered user. They claim to come under 2. By a person other than registered proprietor and registered user in relation to goods or services with which he is connected, in respect of which the trademark remains registered by consent of registered proprietor in a written agreement. And under 53, any user under subclause 2 of clause R is prohibited from filing a suit. This is a clear bar against prayer 2. And therefore, when there is a clear bar against the injunction they have sought, the permanent injunction, the temporary injunction also ought not to have been granted.
Where is the judgment that clause 4? Judgment you are citing that clause 4 has the scope of, it relates to the administration.
Yes, ma'am. As a matter of fact, that entire section 50 has been held to only relate to administration of the trust.
Yes.
Yes. Which your lordship saw Supreme Court judgment, not
Affairs of the trust.
beg your pardon, ma'am?
Affairs of the trust.
Affairs of the trust.
Affairs and administration.
Entirely administration of the trust, which is why they likened section 50 to section 92 of the CPC. Lordship will see section 92. Under 92, my lord, I have to take the permission of the Advocate General or make an application before the court. And then permission is granted to file a suit. It is identical to that. There's one more instructive judgment, my lord, of the Gujarat High Court analyzing this. May I pass it on? This is this one? This one, no? So this exact issue, my lord, was answered by His Lordship Justice Akhil Qureshi. CPC. Good. '92, my lord, is that provision for public trust under the Civil Procedure Code. And the mechanism is, my lord, we must either, it has to be 2 or more persons.
Like public trust.
Public Trust Act, my lord,
Well,
is there.
in the memo of citations that I have handed over, the first document is the Public Trust Act.
'92.
92, my lord, is under the CPC.
CPC.
CPC is 92. Public Trust Act is 50. And comparing the two, my lord, Supreme Court says these are representative suits. '92, my lord, has.
So both operate in the same lines.
They operate on the same line. In the case, my lord, because there's an act specifically for public trust in Maharashtra and, my lord, Bombay, it was called Bombay Public Trust Act, now Maharashtra Public Trust Act. The requirement of the Charity Commission.
What is your answer about section 53 and 52?
Beg your pardon?
Section 53 and 52 of the trademarks.
Oh, that issue was not, my lord, issue was not answered by the judge. The learned judge, my lord, did not answer that question at all. He went straight on the question of public trust and whether the suit is barred by public trust. That contention was not considered by the court at all. As a matter of fact, he says it's a defense. You can take it as a defense. And that's all. Secondly, my lord, I have any number of authorities of the Delhi High Court which have held that even in the suit, in a case for infringement of a trademark by a registered or a user, you are entitled to file a suit because it takes an extremely long time for the registry to actually register a user. In this case, well, I'm suing for enforcement of a contractual right. Lord, my suit is for enforcement of a contractual right. Because of a right, Lord, I gave them under the contract. It was not, Lord, a simplicity suit for infringement of a trademark, like, Lord, under the Trademarks Act. I said because of the termination of this contract, you cannot use the mark. There's a big difference between citing my lord the provision in my humble submission, which is relevant in a simple suit for infringement of a mark, and a suit, my lord, where I have filed for violation of my contractual right. My contractual right is violated, and I now say you cannot use my mark.
So where is that issue framed?
Beg your pardon, my lord?
You said that the issue is framed by the court about breach of section 50, no?
No issue. The application for rejection of plaint, he could have only seen my plaint. He could not have seen the defense of my lord.
There is that discussion about breach of 50.
Yes, my lord. That, my lord, may kindly come in the appeal.
Page 86. No.
Page 71 onwards, but really, my lord, the relevant portion is 86. I'm sorry. Para 15, which your lordship is pleased to see. Please see how the learned judge, my lord, has proceeded. Para 15 at 85. In the present case, it is the allegation of the plaintiff that the defendant association has made use of the mark IEEE, knowing fully well it is owned by the plaintiff, and has continued its breach even in the existence of an interim order. This is a violation. The specific allegation is that the trustees of defendant trust are making illegal use of the trademark IEEE by infringing the trademark, causing wrongful loss to the plaintiff. Also, plaintiff is seeking damages to be paid by the trust or the defendant association for having infringed the trademark owned by him. Though the plaintiff has claimed that it owns the trademark, the relief sought against the defendant is to restrain the defendant public trust from using the trademark, also to direct the defendant public trust to pay damages for infringing the trademark. And it cannot be termed, it says termed, it is termed. It's actually termed. And it cannot be termed as a private or individual right. A contractual right, my lord, is a private right. It is not a public right that I'm seeking to espouse. The court had to consider whether there is a public right of the trust relating to the administration of the trust which was being examined. Instead, Lord says plaintiff is espousing a public right. And then please see the next sentence. Plaintiff is not a single individual, but it is a private limited company under the name Global IEEE Institute for Engineers. It is the institutional right which is being canvassed in the proceedings, cannot be termed as a personal or private right of the plaintiff. And that is the basis, my lord, on which he holds that the right, my lord, which the plaintiff is espousing becomes the ground for deciding as to whether section 50 and 51 apply. That's okay.
Lord, learned senior advocate Mr. Dhyan Chinnappa, assisted by learned advocate Mr.
Shamir.
This should be order, common order in company appeal as well as this is the serial number 35.
35, Lord. It's a single appeal.
Company appeal number 181 of 25 with common order in company appeal number 185, 181 of 25, 181 of 2025 with interim application number 1 of 25 for interim injunction. Heard learned senior advocate Mr. Dhyan Chinnappa, assisted by learned advocate so and so for the appellant applicant. and learned advocate Mr.
Pradeep Nayak, my lords.
Praveen Nayak,
Pradeep Nayak.
Pradeep Nayak for the respondent in respect of admission of appeal as well as grant of interim injunction or otherwise, comma, at length. The appeal is directed against judgment and order of learned 84th Additional City Civil and Sessions Judge Bengaluru in the commercial original suit number 906 of 2024. Which is an order passed under IA.
Aye, Order 7, Rule 11.
Number 4 of I number 4 of 2024 by the said order. The said IA was filed by the defendant, respondent herein, under Order 7 Rule 11 small into bracket A and Order 11 into bracket small d of the Code of Civil Procedure 1908 full stop, allowing the application. The court below rejected the plaint on the ground that it is barred by law under subclause D of Rule 11 of Order 7, CPC. The ground weighed with the court below in holding that the plaint is barred by law under Order 7 Rule 11D, CPC was that that before institution of the suit, the prior permission of the charity commissioner was not obtained by the plaintiff as required, according to learned judge below, under section 50, read with section 51 of the Act.
It's along with the memo of citation.
We don't have Act. The Maharashtra
Public Trust Act.
Maharashtra Public Trust Act 1950. Learned judge, learned court below reasoned while allowing the application under Order 7 Rule 1D that the suit of the plaintiff could be classified as suit based on trademark, and that the right which plaintiff wanted to assert was in the nature of institutional right, whereby the trademark, what is the trademark? IEEE was sought to be enforced and protected. According to learned single judge.
Sorry, commercial code.
According to commercial code below, everywhere commercial code below, comma. No individual right was assigned by the defendant, but the plaintiff was a trust and the suit was.
Plaintiff is a private limited company.
Private limited company and the suit was against the trust. Full stop. In the facts of the case, the appeal deserves to be heard finally. It is admitted. It shall be listed for final hearing on 23rd July 2025. Learned senior advocate for the appellant applicant pressed for interim relief by submitting that throughout the suit, the interim
5724.
57 IN number 1.
47. It was granted on 4/7/2024.
47. 4/7/2024 operated, whereby the respondents by itself or through its agent, servants, assignees, or any other person claiming with the order read as under. The said order dated 4/7/24 read as under. So quote here. Opposing the prayer for interim injunction paragraph. Learned advocate for the respondent heavily relied on the statement of objections filed by him. In the statement of objections, following contentions are raised and elaborated, to contend vehemently that injunction as prayed for is not required to be granted. Paragraph. Firstly, it was submitted that the respondent's right to use the IEEE inward comma mark arises from IEEE. What is INC? INC, and not the petitioner or from the service assistance agreement. Secondly, it was that petitioner has no statutory standing to maintain a trademark infringement action. In the third place, the contention was that neither the balance of convenience lay in the favor of the plaintiff. However, if the injunction is granted, irreparable harm would cause to the defendant.
And as well as the bar under 50 and 51, which your lordship said.
Not even the ground on which plaint is rejected.
At the end of the order, if any contention remains,
please,
you are entitled to remind the court.
Please,
but if you interfere with the order of the court, we are not interested in passing the order in open court.
My apologies.
We are equally free to pass at ease in a calm atmosphere, uninterrupted in the chamber. And that order will be better order for both of you. But still, we are passing the open court order and we request you not to interfere.
I fully appreciate. My apologies.
And that request I have to do every time since 1 year before this bar. And whenever I dictate the order, I don't tolerate any interference, Mr. Counsel.
Please,
it breaks my chain of thought. Yes, what did you write? The fourth contention was that the injunction granted on 4/7/24 was only an ex parte injunction which cannot be permitted to be continued nor can be relied upon. The fifth contention was that the respondent has complied with the interim order. In that view also, as and there is no need to grant the interim injunction. The sixth submission is that the suit is barred by law in view of section 50 and 51 of the Bombay Public Trust Act, as also under section 52 and 53 of the Trademarks Act. I write down here. trademark set which inter alia debars the, which India doesn't permit the unregistered user of the trademark to seek any relief against the registered user. Full stop. On the other hand, learned advocate for the applicant highlighted the nature of the suit with reference to the prayers, with reference to the suit prayers. Full stop. It is to be noted, paragraph, that in the suit the plaintiff has prayed for the following prayers. So agree on this A, B, C, A, B, C, page 114. Based on the termination notice given by the plaintiff in respect of terminating notice given by the plaintiff dated 2nd May 24, whereby the service assistant agreement dated 29th August 2012 was terminated. It was submitted that the cause of action to institute the suit arose for the plaintiff in view that despite the termination notice, the respondent continued to use inward comma IEEE brand, mark or name. It was submitted that the suit was based on the service assistance agreement and thus the rights asserted by the plaintiff was in the nature of contractual, and it could not be, and the suit could not be termed as infringement suit per se. Full stop. Section 50 and 51 of the Maharashtra Public Trust Act are relevant to notice in light of the only limb of the order of the commercial court for rejecting the plaint on the ground that the suit was barred by those provisions. Full stop. Section 50 of the Trust Act relates to the suit by or against or relating to public trust or trustees or others. Whereas Section 51 contemplates consent of charity commissioner for institution of the suit of the nature contemplated in Section 50. Full stop. What learned advocate paragraph for the respondent relied on was clause Roman small 4 into bracket of Section 50 to submit that a suit which is for any declaration or injunction in favor of or against a public trust or trustees or beneficiaries thereof would not be instituted without the prior permission of the charity commissioner full stop, according to learned advocate for the respondent, full stop. The instant suit would fall under clause Roman small 4 above to be barred by section 50, and that the commercial court below has rightly concluded that it is so barred. Full stop. In this regard, learned advocate for the appellant applicant relied on decision of the Supreme Court in page 180, 181.
At 189, para 13.
In Vinayaka Dev, Idagunji versus Shivarama, SHIVARM and others, 2005-6 SCC, page 641, in which the Supreme Court observed thus. So paragraph 13, then below paragraph into bracket paragraph 13. What was highlighted was that the provision of section 50 has the analogy of section 92 of the Code of Civil Procedure, and that both the provisions are in the nature of representative suits, which pertain to public trust and protection of public interest in the trust. It was sought to be contended that, having regard to the kind and nature of the subject matter of the suit and the prayers made, it could not be said to a suit relating to the affairs of the public trust. In Vinayaka Dev Supra, it was the right of the Acharakaship which was claimed on the basis of inheritance, and the Supreme Court held that section 50 of the Trust Act was not retracted. It could be paragraph prima facie said that clause small Roman 4 of section 50 of the Maharashtra Public Trust Act in its scope and ambit is referable to the areas of is referable to the subject matter, where the area of dispute is administration of trust or the affairs of the trust. Full stop. At this stage, for the purpose of considering of interim relief, it could be noticed that the suit appears to be based on contractual obligations which are agitated by the parties on the basis of, with reference to the breach of service settlement agreement, service agreement, service assistance agreement. Although the issue is to be finally threshed out at the time of final hearing of the appeal, it is to be noticed that paragraph is to be noticed that the commercial court below proceeded to hold that the plaint is rejected under Order 7 Rule 11 DCPC for the following reason. Then quote from page 86, though the plaintiff has claimed the above to though the plaintiff is up to barred by law and according barred by law. Full stop. The aforesaid reasoning is to be examined for its merit in light of the contention of the appellant applicant that the suit is not a trademark suit and it is based on contractual right arising out of the termination of the service assistance agreement. Full stop. The contention about breach of concerns about the suit having been not maintainable in view of section 53 and 52 and 53 of the Trademark Act does not call for consideration at this stage, since the impugned order is based only on section 50 and 51 of the Maharashtra Public Trust Act. It appears to the court that even otherwise, the contention with regard to the non-maintainability of the suit with reference to the provisions of the Trademark Act is a contention, again, in the realm of merit to be tried in the suit itself. Although the court does not express any final opinion thereof. Full stop. Court is not impressed with the submission that the interim order which is sought at this stage could not be granted because the earlier granted order was ex parte, and that now the appeal is now the suit is held to be barred by Order 7 Rule 1D. Full stop. When the prima facie case and serious debatable issues are found to be ignored in the subject matter, non-granting of interim leave will tilt the balance of equities and the appellant plaintiff would be put to serious prejudice in respect of the rights claimed in the suit. Balance of convenience lies in favor of the appellant plaintiff. In that view, there shall be interim injunction in the same term which was passed by the commercial court below on 4/7/2024 to continue till the final disposal of it. वो मिल जाएगा इनसे, we'll be able to find out.
Your lordships kindly.
Yes.
Serial number 36, the next matter. Mr. Chinnappa is on the other side. Your lordship.
We'll start because that is on that arbitral award.
There's already an interim order passed by your lordship not to precipitate the matter. Your lordship have it 2 weeks hence, my lord. I will also file my pleadings. And then
It's an appeal,
the matter could be heard and disposed of.
It's a 37 appeal. Interim
Fair
order has been
enough.
granted.
I'll file my objections to the grounds that have been raised. Your lordship may have it 2 weeks hence.
It was started, hearing was started.
I started,
No, no, no.
as a matter of fact, I
Only
started.
Only interim order was granted. Thereafter, your lordships issued notice. On after notice, my lord, we are here. My lord, it's a 400-page order passed by the learned arbitrator, my lord. I mean, it will require some hearing to be done. I don't think in half an hour it can be done.
In appeal, what? In appeal, what reply to be filed?
No, no, I will just file the
file
a
no,
synopsis or something.
some
Your lordship
synopsis.
may grant me 10 days time, my lord. I will.
24th for the time.
24th.
For the time being 24th.
Would your lordship have it on 28th, my lord?
That is almost last day of vacation.
No, no, that whole week is still
No,
there.
28th and 29th only days.
26th also working.
It's
26th.
28th, your lordship.
26th.
Monday the
No,
28th.
no, 28th.
28th, there are some matters which may take.
26th, your lordship.
26th.
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 Right.
My lord, serial number 61, my lord. I'm making mention for this reason, my lord. My request for tomorrow at 2:30, SLP preferred by the state government is dismissed, my lord. Matter pertains to compassionate appointment. Complainant is under financial distress, my lord. My request for 2:30, my lord, tomorrow.
Due date is listed.
It is listed, 61.
How do you say that it will not reach?
I have some difficulty, my lord. May I
That's
request
a,
for,
that's a different thing.
please, my lord, please.
Either today or after vacation.
My request for tomorrow at 2:30.
Not possible. Lot of matter to be dealt with.
Your lordship also.
One not. There is a delay of 41 days. We'll issue notice. Notice returnable on 11th June. All office objections are deferred to be considered on that. The note can be done without condoning delay. Unless delay is dealt with, no further order can be. All are appearing. All parties are there, here appearing. Then notice has to go. If you are serving by delivery, we can keep before vacation to give you a chance. But notice will have to serve. So second is working. 2nd of May. Service by hand delivery is permitted. Yes, anything? Anybody? Yes.
Lordship, serial number 51.
Oh.
Emergency today, Lordship, if possible.
Ask her to mention.
I'm already copy served to the respondent advocate, Lordship. And some urgency in this matter. Admission is started in. I'm sorting this matter, Lordship. Petition is
Wait.
Today, Lordship.
Day is not over. Wait. Wait.
Please.
Mention if it doesn't reach at the end of the.
Please.
Your Lordships have Lords permitted the encounter killing matter to be listed at 2:30 because there is a risk, Lords, that the cremation may take place without the post-mortem and other requirements. Lordships may kindly take that up.
We'll take up later. We have said yes to be taken.
Seal number 105.
My Lord, I have informed all the council. I think some of them are present here.
I am for the first respondent caveat term, my Lord.
There is a leave to appeal because I was not a party to the writ petition. I am affected by the judgment which held that the central government had no power to make the rules. And therefore, I am aggrieved by that.
You are not a party in any of the petitions.
I was not a party in the writ petition because there is no relief asked against me. They challenged, they raised some grounds, and the learned single judges held that the central government has no power to make rules, and consequently is held that the state commission, which made the regulations under the rule, is also bad because it was made under the rule. The learned single judge does not find any constitutional violation of the regulations with any part of the constitution, nor does he find that there was any procedural irregularity, only because the regulation state by saying in accordance with the rules have been struck down as ultra vires, and therefore the regulations have been struck down. Now the state commission has made further regulations, but that is a separate matter. I am aggrieved by the finding that the central government has no power to make rules, because according to me, all state commissions under 181 have to make regulations consistent with the rules. Kindly see the Electricity Act, madam. And the Union of India has also come
The
up with
identical matter was filed by Union of India and it is posted on 23rd, my Lord.
Yes.
Please, the petition admission is, my Lord, one issue. But if the other parties, the parties should be, my Lord, notified, because your Lordships may see the impugned order. There are about 20-25 Lord petitioners who all have to be served, because there were 3 councils who represented, my Lord, and their viewpoints were different.
That's a different thing.
Yes.
Then we are dealing with the leave to appeal application.
Yeah, that, my Lord, because the the petitioners, my Lord, should be the pro forma respondents in this matter. They also have a right of audience. They should also be made a party. I am one of the, my Lord, one of the petitioners who is now made a respondent. Kindly see, my Lord, how many more parties are there. The varied interests involved.
And I have made you a party in the writ appeal.
Correct. There were, my lord, other parties whom I represented, and also other two councils represented.
We bought all the petitions, no?
So they are all necessary parties, my lord.
He made only Vrindavan.
For instance, in page 53 is represented by another council. All
You are-
these, sorry.
You are Ultratech.
Yes.
I am Ultratech. I have filed a writ appeal against the judgment in the main writ petition, which is filed by Vrindavan. And I've made all the parties in that writ petition parties to my writ appeal.
It's a common order, my lord.
So have we not filed appeal?
Why should I file petition?
But some step we have to take.
Lord,
So this IA2 of the 25. Grant.
my prayer is, my lord, from page 47 to 80 is the array of parties. Now their interest is also affected, and they have a right, my lord, of audience.
So this is our writ appeal number, writ petition number, first writ petition,
Our appeal.
You showed 1, 1, 2, 3, 5. My lord, the first writ petition is
Whatever you want,
Sorry, my lord.
whatever you pray or request,
Yes.
you are requesting that all should be pro forma respondents.
Yes, because, my lord,
File an application. That's the difference.
no, my lord, they are aggrieved by a common order, and there are multiple beneficiaries.
Theirs is today an independent application for leave to appeal,
Yes.
and they have filed a substantive appeal also.
yes, I have filed a leave to appeal against a judgment in WP 11235. It is a common judgment in several writ petitions. One WP 11235 of 2024, Vrindavan. I have made all the parties in that writ petition respondents here. And I've made the Union of India also respondent. I don't have to file, my lord, writ appeals against all the writ petitioners.
No, the norm is, my lord, that in the writ appeal, whoever are the parties to the original side, my lord, are made respondents and their rights are affected. I'm not saying, my lord, that I have my objections for this, my lord, leave and other issues.
Common judgments is relatable to, referable to A, B, C, D, E, F
Yes.
petitions.
Please.
It's
No, the submissions were different, my lord.
Kindly listen.
Please.
The present applicant wants to be an appellant
Yes.
in respect of decision which concerns
Please.
say petition.
Yes.
Please.
So why can't it be granted?
Insofar as that petition is concerned, if your lordships are,
He is appearing for Vrindavan. Does he have any?
no, they are sailing together.
Which your lordships have already admitted.
Yes, I've mentioned it to my lords.
That I don't dispute, my lord. Both I don't dispute. I am saying, my lord, if the interim order is to be concerned, interim order is to be considered, then, my lord, their rights will be affected, is what I am saying. For leave, my lord, of course, in my writ petition, that is, my lord.
My lord, he can't have any objection to my filing a writ appeal and
I am the-
been given to him.
Two of 25 is granted will be dictate the order.
Yes.
As far as the appeal is concerned, heard learned senior advocate Mr. P. Chidambaram, assisted by learned advocate Mr. So and so. Full stop. In the facts of the case, the present appeal is directed against judgment and order dated 20th December 2024, passed in common in several writ petition insofar as it concerns writ petition number 11235.
Yes.
11235 of 2024. Full stop. In the facts of the case, the appeal is admitted. Full stop. It was stated that writ appeal number 154 of 25 arising out of same common judgment and order was dealt with by this court at the admission stage, and same is admitted as per order dated 23/6/25. In that view, the present appeal shall be listed along with writ appeal number 154 of 25.
Wait.
On
23rd, my lord, is the date on which the
I
other
have
appeal is
a
posted.
request. Your Lordship is granting me leave to appeal. Your Lordship is granting me, I'm grateful. There is also a formal application for condonation of delay,
That
but
is
there is
also
really,
That is also
obliged, fellow, obliged. Then the third application is for stay. Your Lordship may hear the stay petition on a suitable date, and I will assist your Lordship.
But the appeal is already directed to be listed when? This appeal?
23rd, my lord.
23rd
Of June, 23rd June, my lord. For final hearing. In fact, it is for final
But,
hearing.
I have no objection. I'll be happy to assist your Lordship on 23rd of June. But there was an interim arrangement before the learned single judge when the writ petitions were pending. After the disposal of the writ petitions, the learned judge served interim directions. That interim directions have lapsed because of the new regulations. I only want your Lordships to decide and hear and decide whether any interim arrangement should be made. Because, my lord, we are consumers of green energy. It will only, we are consumers of green energy. There was an interim arrangement pending the writ petition and post the writ petition.
That I support. That I support. That I support. That is because, in fact, my lord, I will go 2 steps further.
Can't we prepone the very hearing of the appeal?
Sorry. Yes, no,
Your
in
Lordship
fact,
may decide to hear the writ petition. I have no objection.
Now we can we can fix your appeal earlier
Yes.
and hear it. It is
Please.
both
clubbed
ways.
with that matter. Yes,
Automatically the other appeal gets.
will get clubbed with this. Yes.
So whenever soon after.
Even today, my lord, as my learned senior is saying, if the arrangement is made,
So only idea is not to deal with the appeal piecemeal for first interim order, because in this earlier appeal, no order was passed. As
no,
far as
there
interim
was
order
an.
is-
No, the
And
learned single judge.
nor was even pressed probably.
No,
It was
there
pressed, but declined, but declined.
I have filed an application for interim stay. Lord, earlier for want of time and other things, Lordship had indicated that it will be considered in June.
Yes, yeah, I'm whole of June is-
It was already listed for final hearing.
Yes, but
It's earlier appeal.
my lord, there is one distinction between the Union of India's appeal and my learned senior's appeal. We are all aggrieved, my lord, by the charges fixed.
People argue in the writ appeal, nah. Now my
Right.
lords.
The
only
interregnum, my lord, if the 50% arrangement is continued, as per the learned single judge's order.
Now when shall we fix this appeal? For
Whenever your
for
Lordship-
hearing of the appeal as well as interimly, whatever you.
After opening, I suppose.
Yes.
Any date your Lordship may fix.
16th.
16. Well, the second week is 9th. First week I understand. Second week is 9th. Can it be fixed?
10th.
Obliged, deeply
10th.
obliged.
So appeal shall be listed for final hearing on 10th.
Yes.
The other appeal, which is cognate.
That is already
Number
posted for
154 of 25, which is cognate, shall also be listed on.
Yes.
And the stay petition also will be posted on that day.
Yes, along with the
Obliged.
stay, along with the
Obliged.
stay application.
Obliged.
Yes.
So preference would be subject to what all, how you. say
In the-
amendment.
in the meantime, my
Preference
lord-
will be to hear the amendment, hear
Yes.
the appeal itself.
Yes, please hear the appeal. If for some reason your Lordship is not disposed of the appeal, then your Lordship may consider the stay petition.
There is yet another aspect, my lord. In the Union of India's appeal also, these parties were not represented. They took just one party a respondent because they also need to be notified and we have a right of audience. That's what I'm saying. That's all I'm praying. I'm grateful to my learned friend.
Whatever step you.
Because
Much before the next step, Lord, I will
Yeah,
ensure that.
grateful.
My lord, I may be permitted to take notice for respondent number 6, my lord. In this appeal.
Learned advocate, Mr.
KES.
KES.
Just notice on behalf of number 6.
Yes.
The rest of the respondents will be served.
Your lordship, I appear for respondent number
He is
5.
also there.
So
I
whatever
appear for respondent.
Service may be complete.
Whoever accepts will record and the rest of the response will be.
Grateful.
Obliged.
Grateful.
Obliged.
Till number 81.
The appellant before my lordships is the
You are
national.
supposed to, office objection is that you are supposed to file commercial appeal.
My lord, what has happened is it's only I just had to name it as COMAP. In all other ways, it's compliant, my lord. It's
No,
only
the nomenclature
the
of this proceeding has to be commercial appeal, not MFA.
my lord. So, but that's the only classification which my lord may grant me leave to just convert it as a commercial appeal. In all other ways, the appeal is compliant with the requirements of a commercial appeal, my lord. It's just the nomenclature that is wrong.
I don't know, it has to be registered as a commercial formally before we could take up.
My lord, my only difficulty is this, my lord. The attachment warrant has been issued. In fact, I'm given to understand that Amina is awaiting instructions from this honorable court in these matters because they're already in the office of the project director. There's a serious question of law involved over here, my lord.
The present appeal, present MFA when comes up for consideration, the office objection notice is that instead of miscellaneous first appeal, the same ought to have been filed and registered as commercial appeal. This is in view of provision of section 13.
The Commercial Codes Act, but
13(1)(c), 1A, full stop. In that view, upon request of learned advocate so and so for the appellant, permission is granted to convert the MFA to commercial appeal. Full stop. Learned advocate for the appellant undertakes to file a fresh memo in the registry with titled as commercial appeal in course of the day.
Hello.
Full stop. The registry shall register the appeal as commercial appeal and post for admission tomorrow. Full stop. It was stated by it was submitted by learned advocate for the appellant that the attachment is likely to take place today. Full stop. In view of that, the present appeal is going to be listed as commercial appeal before this very bench itself tomorrow as directed above, interim protection is granted to the appellant, directing that there shall be no attachment.
The attachment warrant is stayed, my lord.
Till tomorrow.
My lord, oblige me. 82 is a similar.
Same order, 82. Tomorrow is so that this we are processing of something on tomorrow. Tomorrow, where is the council?
I appear, my lords.
Anyway. So tomorrow further.
Please.
Tomorrow the present MFA as well as the commercial appeal both shall be listed.
Mentioned matter, writ petition 11,397 of 25. Shrimati Mrudula.
I beg to appear, my lords. This is a petition by PUCL, my lords, who was the petitioner before the Supreme Court in the landmark judgment of 2014 relating to police encounters. Now here, my lords, a police encounter death has occurred on 13/4/2025 in Hubli. And in terms of the directions in para 31(3), my lords, of the reported judgment of the Honorable Supreme Court in PUCL, which we are furnishing to your lordships, at this stage, my lords, three things are to be done. One is, of course, my lords, the registration of an FIR. And then, my lords, if your lordships see 31(3) B, E, and F, I hope your lordships have the copy, my lords. As per my lords 31(3) B and F, the body is to be subjected to a post-mortem to be conducted by 2 doctors in the district hospital which is to be videographed, my lords, and preserved. Then, my lords, fingerprints and hair samples are to be preserved. Now, we have learned, my lords, that there is an apprehension of the cremation taking place today.
It is some, it is. I was busy with the. Yeah, yeah, yeah.
What is judgment?
Yes, just making it available to your lordships.
Excuse me.
This is Zahira Habibullah and Akil. And these. I just, I'm in a.
Yeah, listen.
Is there another copy of this?
Give me one copy. You gave me two. Yeah.
I have to give the code.
We look for madam, kindly make the copy available for the bench. We have given you a copy.
No, give it to the.
Please, my lord, see the directions in PUCL. This is, my lords, the landmark judgment dealing with police encounter cases. If your lordship see 31.2, my lords. I had printed page 655. May I read to your lordship's notes?
What was the crime, Mr. Sanghi? 376. 376.
The FIR, I'm told, was registered, my lords, under POXO and, my lords, for murder. The victim was a young child of 5 years.
5 years.
Now, on that same afternoon, my lords, a 35-year-old individual, my lords, was subjected to a police encounter, which on inquiries we have learned took place about 10 kilometers from the spot where the original incident occurred. At this stage, my lords, I am not entering into any adversarial accusation against the state. I am only pointing out the mandatory directions, my lords, of the Supreme Court in PUCL. If your lordships permit me to read 31.2 and 3. Please, my lords. If pursuant to the tip-off or receipt of any intelligence...
Wait.
Please, my lords.
31.2, my lord. 31 point.
Point 2 at 655 printed page.
650. Yes.
Grateful, my lord. If pursuant to the tip-off or receipt of any intelligence as above, encounter takes place and firearm is used by the police party, and as a result of that death occurs, an FIR to that effect shall be registered, and the same shall be forwarded to the court under section 157 of the code without any delay. While forwarding the report under section 157, the procedure prescribed under 158 of the code shall be followed. Now, my lords, 31.3, which are the directions. An independent investigation into the incident bar encounter shall be conducted by the CID or a police team of another police station under the supervision of a senior officer, at least a level above the head of the police party engaged in the encounter. The team conducting the inquiry bar investigation shall, at a minimum, seek A, to identify the victim, color photographs of the victim should be taken, then B, my lords, to recover and preserve evidentiary material, including blood-stained earth, hair, fibers and threads, etc., related to the death. Then to identify the scene witnesses with complete names, addresses, and telephone numbers and obtain their statements concerning the death. Determine the cause, manner, and location and the time of death, as well as any pattern or practice that may have brought about the death. Then E, my lords, it must be ensured that intact fingerprints of the deceased are sent for chemical analysis. Any other fingerprints should be located, developed, and lifted and sent for chemical analysis. And then F, my lords, relating to the post-mortem. Post-mortem must be conducted by 2 doctors in the district hospital. One of them, as far as possible, should be in charge bar head of the district hospital. Post-mortem shall be videographed and preserved. Any evidence of weapons such as guns, projectiles, bullets, and cartridge cases should be taken and preserved. Wherever applicable, tests for gunshot residue and trace material detection should be performed. The cause of death should be found out, whether it was natural death, accidental, suicide, or homicide. And consequently, my lords, in 31.4, a magisterial inquiry under section 176 of the code must be invariably held in all cases of death which occur in the course of police firing, and a report thereof must be sent to the judicial magistrate having jurisdiction under 190. The rest, of course, are, my lords, consequential directions. If it is found that something is amiss, then action against the officers, etc. My lords, we are not at that stage now. And these directions, my lords, in para 33, have been held to be binding directions, my lords, within the meaning of Article 141 of the Constitution, that your lordships get in para 33. So at this stage, my lords, regardless of whether the encounter, my lords, was bona fide or not, these requirements, that is the registration of an FIR, to be looked into by the CID, my lords, or an external police team, must be done. And as far as the body is concerned of the deceased, the hair samples, the fingerprints, and the post-mortem, my lords, is to be conducted in terms of 31(3) B, E, and F. And your lordships have seen in F, my lords, the manner of the post-mortem is also prescribed, that it is to be videographed and to be conducted, my lords, by 2 doctors, one of whom at least should be the in charge or head of the district hospital. Now, we have learnt, my lords, that the cremation of the deceased is likely to take place today. At this stage, my lords, I'm requesting that the body be preserved, my lords, so that the requirements of 31(3) B, E, and F can be met. As to what the outcome thereafter, my lords, of course, will depend on the magisterial inquiry, as also the investigation, my lords, by the CID pursuant to the FIR that is registered. That stage, of course, will come a little later. And I have averred in my petition at, my lords, page 15, that on inquiry, my lords, the cremation is likely to take place today. The incident took place, my lords, day before yesterday, that is 13/4.
You are not going to. You are not.
We have already just 2-3 submissions, my lord.
You are not going to conduct post-mortem.
We are doing it, my lord. This is, I mean, we have already registered an FIR. Copy of the FIR is already there. We are complied with. We are already handed over to the CID. CID is investigating. The Lordship may direct us to comply, strictly comply. We are doing it. And there's no question of cremation. And ultimately also it is only burial, because we may exhume after 6 months, 1 year. So therefore the question of cremation does not arise. We are strictly following this. Your Lordship may kindly, FIR has been registered immediately against the concern. Is handed over to CID.
But the burial of my friend is making that submission. I would request your lordships to notice it, because the deceased was a Hindu, and there is therefore an apprehension that, my lords, a cremation may take place where the body is then burnt.
No. In all such incidents, as a matter of law, my lords, there's no cremation done. It has to be burial, my lords. In such incidents, my lords, because we may require it at a later point of time, is my instructions. Even where
we would not want, my lords, to go.
body is not, I'm sorry. Body is not yet identified, my lord, because unless the body is identified by the parents, whoever or the relative saying that it belongs to so and so, question of we cannot even do the post-mortem, my lord. So the question of cremation, as my learned friend's apprehension, is not the maybe genuine apprehension. There no such cremation immediate urgency to your lordship's query, my lord. And we are strictly this is a document to show it had been handed over to CAD as per 31.3, my lord. I've got the copy of the FIR as required under 31.1, my lord. That has been done.
Now that my friend lords is fairly submitted before your lordships that the cremation is not taking place, then lordships may keep it after a few days so that the state could report to your lordships, my lords, on the
Or
steps.
learned senior advocate Mr. Sanghi for the petitioner.
Only, my lords, I'm sorry.
And learned Advocate General Mr. Sasikarna Sethi, assisted by learned additional government advocate Srimati Nilu Bharakpur and learned advocate Miss
Anukanksha.
No.
Anukanksha.
Anukanksha for the respondent state upon service of copy of the petition in advance. Also, the petitioner happens to be People's Union for Civil Liberties, Karnataka, stated to be an organization working with the objective of securing rule of law and defending the civil liberties of the minorities. The issue flagged in this, sought to be flagged in this petition is about extra judicial killing of one Ritesh Kumar, whom a migrant laborer from state of Bihar. Full stop. The incident of encountered killing took place on 13th. Alleged encounter killing took place on 13th April 2024. Full stop. The said Ritesh Kumar was accused of killing a 5-year-old child within the limits of Hubli Dharwad district, and that a case under the POXO Act was registered, and the offences under the POXO Act were registered against the accused. It is the case that paragraph. It happened on same day?
Yes, 13/4.
Same day.
Please.
13th was the incident, my lord.
Same day. And same day. It is this case of the petitioners that around 10:45 on 13/4/25, the police received a complaint that a dead body of 5 years old girl was found abandoned, lying at the shed in the Vijayanagar area. The police swung into action and tried to trace the identity of the criminal, alleged perpetrator, who was thereafter traced through CCTV footage. It is the case that on the same day, the said Ritesh Kumar, aged 35 years, was shot to death by the police. Full stop. Elaborating the case based on such basic fact and premise, the prayer is made in the petition to direct the authorities to preserve the bodies of the deceased as accused, who was killed on 13th April 2025. It is the next prayer to direct the formation of the special team of autopsy, surgeons, forensic experts preferably from New Delhi or from the state other than Karnataka, to undertake an independent examination and to do autopsy of the dead bodies of both the deceased and the victim. Full stop. Learned senior advocate for the petitioner relied on the decision of the Honorable Supreme Court in People's Union for Civil Liberties and another versus State of Maharashtra and others, 2014-10 SCC 635, in which the Supreme Court has proceeded to lay down the guidelines to be observed by the police and other authorities in cases of police encounter cases resulting to death of the persons. Full stop. It was submitted that the respondent authorities are bound to obey the directions of the apex court, which are contained more particularly in paragraph 31.2 onwards. Paragraph. Notice returnable on 24th of April. Full stop. Learned senior advocate presses for interim leave to submit that the body of the accused killed in the encounter has to be preserved by the respondents authorities, so that the evidence as may be required during the investigation are available. It was submitted that the body is cremated. Evidence would be lost, and the rule of law would suffer. Full stop. Learned Advocate General submitted in this regard paragraph that the question of cremation of the body does not arise, as in such cases the body, if at all to be given to the family members upon identification,
It is
it would be permitted to be buried only, and that there will be a burial, and in no case the cremation would be permitted, so that the body could be
exhumed at a later point of time if
at a later
required.
point of time as may be required in course of the investigation. Full stop. Having noted this submission, it is to be observed that the apprehension on part of the petitioner that the body of the accused would be cremated is not well placed. However, in order that the objective investigation is carried out, following directions are issued as interim directions. Full stop. The respondent shall, small Roman 1. The respondent shall scrupulously adhere to the guidelines and directions of the apex court in People's Union for Civil Liberties Supra in paragraph 3.3, which are as under. So A to H paragraph, after quoting, it is further provided that the body of the accused shall be subjected to post-mortem by a team of 2 doctors.
In terms of this,
at the local hospital,
please,
where the post-mortem is to conducted as per the directions issued by the Supreme Court. Noted here in above. It is further directed that videography shall be undertaken for the entire duration of the post-mortem.
And we'll place the affidavit on next date of hearing, my lord, what and all we have done.
You preserve the part.
We'll preserve, my lord, whatever is required, we'll preserve till next date of hearing, because now we are not.
So provided that the authorities shall preserve the samples of the parts of the body collected during the post-mortem process, the process of post-mortem.
Please, my lord, that should
to be made available as may be required
for investigation.
for investigation.
And
Very
we'll file an affidavit to that extent before your lordship.
Affidavit shall be filed before the next day.
And those will do that.
I'm so grateful to your lordship.
Copy of the order.
Can I request the court martial to give the copy so that
Copy of this order shall be available
so that we can
at the registry to learned additional government advocate
Obliged.
grateful,
immediately. So first type out and then send.
grateful to.
So very obliged.
But in any way you have to communicate.
We'll write now, they are the present, it will be communicated so that not even one word that.
Their concern, immediate
We'll do it,
concern
we understand, my lord.
about you.
We understand that.
Grateful to my friend as well. So grateful. So grateful to your lordship.
Whatever Mr. Sanghi, the office objections are to be complied with.
Yes, of
Including
course. We will do so.
Office objections,
Urgency.
including payment of court fee, 100 rupees, shall be complied with within 1 week.
So obliged.
Please, grateful.
Number 108. Mr. B.C. Prabhakar.
Please, my lord. My lord, this appeal has more or less worked itself out. May I just tell my lord, even without troubling your lordship to go through the papers, the single judge passes. The single judge.
Arun, but advocate was appearing for R1, my lord. He has retired, my lord. I am filing wakalat on behalf of R1. Some time may be granted to me.
So this learned single judge, my lord, he essentially gave two directions. First was, please do not proceed with the inquiry. This is a disciplinary matter. Please do not continue with the inquiry. Second is directing the workman, the charge-sheeted employee, to approach the labor court for clarification under section 13A of the Standing Orders Act. This was the impugned order before your lordship. Your lordship allowed me to conduct the inquiry. The inquiry has been concluded. The workman approaches the labor court. The labor court has passed its order in terms of 13A. The workman has now challenged that order by a separate substantive writ petition before the single judge. Now the matter has gone before the learned single judge.
What is the outcome of inquiry?
I'm so sorry, my lord.
What is the outcome of inquiry?
I am not aware of that, my lord. What the outcome is, in any case, I'm given to understand.
What is challenge before learned single judge?
The order of the learned labor court in terms of section 13 capital A of the Standing Orders Act. Your lordship recollects the question.
That was already challenged when this appeal was filed.
No, my lord.
No.
What happened was, it was the case of the charge-sheeted employee saying that I want to be represented before the inquiry officer by one particular individual. Then the question arose whether that power exists. So the learned single judge says, under section 13 capital A of the Standing Orders Act, let the labor court decide this issue. And in the meantime, do not hold the inquiry. So what your lordship did was, on my appeal, allowed me to conduct the inquiry, at the same time allowed the matter before the learned labor court to proceed.
You have conducted inquiry.
Yes, and copy of that inquiry report has been given to the charge-sheeted employee. He has given his submissions regarding that. Now that is under consideration by the management. So that's one part. The other part is, my lord, that 13A Standing Orders Act, the final order has been passed by the learned labor court. That the workman has challenged before a learned single judge of this high court by way of a separate writ petition. Now in that writ petition, the learned single judge passes an order and says that that order that of the learned single judge there be placed before your lordships, considering the writ appeal.
Interim order.
It's an interim order. But to my mind, my lord, nothing turns on it. Now this writ appeal has worked itself out. And if he has any grievances, he's already before a learned single judge. He may work out whatever he wishes to over there.
Fair enough.
Earlier, my lord, may I make a submission? Earlier, Naren, but
what is the order? Let us.
Yes.
Since learned single judge sent to us,
Yes.
we must read it.
Yes. So I prepared this compilation, my lord. One is the learned single judge's order, and the second is, my lord, the order of the court below, that is the labor court. Your lordship sees the second page of the learned single judge's order, that is D, page 2. May I read, my lord? The Labour Court should have therefore independently examined the question after considering the liable submissions in the light of the provisions of the Model Standing Orders, as also the relevant provisions of the Trade Unions Act 1926. On the urgency, Mr. Narayan Bhatt submits that the inquiry as against the petitioner, even without the assistance, is completed, but such report is not given effect to in view of the interim orders granted in the other writ proceedings. And if there is no interim order, the petitioner will be served with a dismissal order leading to precipitation and further protraction of the dispute. In consideration of these submissions and to ensure that there is no precipitation or unjustified protraction, interim order is granted staying the operation of the Labour Court's impugned award dated such and such, subject to further orders pending in writ appeal 1603, calling upon the learned counsel for the petitioner to place a copy of this order in such writ appeal and to ensure that the copies of the petition are served on the learned counsel for the first respondent in such. So instead of the petitioner there doing so, I am placing it before my lord.
So ultimately, what is done by learned single judge?
The learned single judge is really, you see, my lord, under section 13A of the Standing Orders Act, the learned Labour Court comes to the conclusion that the prayer of the workman, that I want Mr. So-and-so, a specific individual.
What happened to that issue before learned single judge?
The learned Labour Court has said that cannot be done in these proceedings.
No, learned single judge said what? Nothing.
Effectively, the learned single judge has done nothing. But either which way, now that that petition is pending.
Some finding about whether that person is to be given to the delinquent for as a representative. What is the finding of learned single judge? Nothing.
Learned single judge has not given any such finding.
So what he has said?
He has only stayed the operation of the Labour Court's award. The Labour Court says that this question, whether or not a particular individual can be appointed, cannot be gone into in these proceedings.
So then this writ petition is pending before learned single judge.
Please. Therefore, my submission was this writ appeal has worked itself through.
True. Read the earlier order dated 25.
Yes, if your lordship sees your lordship's
so we
previous
read this 25 and 24 with this order of learned single judge.
That's right. The writ appeal.
Pendency of two proceedings. Yes. One unconcluded inquiry before the management, inquiry not concluded before the management, and the writ proceedings not concluded before the learned single judge.
I make a submission.
What remains?
Senior counsel is.
May I, my lord, make a address your lordship, my lord? The advocate. Yes. May I address your lordship, my lord?
Yes, please.
My lord, the lawyer appearing for the Federation last night informed us that he would be discontinuing. So we immediately contacted the lawyer at in the state, and he's ready. He wants to file wakalatnama.
Write down. Learned senior advocate Mr. Narayan Bhatt appears through video conferencing with learned advocate Mr.
Vishwajit Ray.
Vishwajit Ray.
No, he has now retired from the case, my lord. Senior counsel is one Colin Gonsalves, my lord.
You are Vishwajit Ray.
Yes, my lord. Yes.
With Mr. Bhatt.
Yes.
Seeking to file your wakalatnama.
Yes, my lord. I'll do that.
Mr. Ray, present in the court, stated that the earlier learned advocate who appeared for the respondent has retired, and that he is to file his wakalatnama on behalf of the respondent, for which
colleague of Narayan Bhatt
reasonable time is granted. When you will file?
I will file it within 3 or 4 days, my lord.
He stated that the wakalatnama will be filed within 3 or 4 days. Put up after vacations.
After vacations, my lord?
Naturally, no time.
Yes.
I was hoping, my lord, that if it could be, because it's
Date
now
after
it's really
15th,
worked itself
15th
through. Now it's only a matter of 5 minutes. I'll not trouble your lordships with more than 5 minutes.
No, I had
That is, I was
requested
only
my
hoping.
I had requested my learned friend that I would be seeking time because in view of the fact that I would be filing wakalat.
If you heard the submission.
Yes, my lord, I heard, my lord. No, I didn't have the papers, my lord. I'm very sorry. 15th of June, my lord, after 15th of June.
Would your lordship then consider the first week of June, my lord, considering Delhi is shut in June?
No, first week of June, my lord, there's a marriage in my family, my lord. So
17th June.
very well, grateful.
My lords, I'm appearing for respondent number 4. I'm just a pro forma party. Respondent 4 is the inquiry officer. But I have filed my wakalat today.
You want us to record?
Then could I request
is
your
fine,
lordship to have it on the 1st of July possibly, my lord, instead of
July,
1st of July, Tuesday,
8th of July,
9th of
9th July.
9th July. We're grateful.
Grateful.
Grateful, my lord. We'll be ready.
Hearing ki nahi?
Seal number 109.
Before that, one second. Number 93
Pay for
to,
petitioner lordship.
one second, 93 to 96. 4 weeks time is granted, 6 weeks time is granted to remove the authorization. Failing with the appeal shall appeal or whatever, automatically dismissed. So in 97, 3 weeks. 98, 4 weeks. Array, 3 weeks. And this is over. Yes, now continue.
Appear for petitioner lordship.
Serial number
109.
101, 109. This can wait after vacation.
My lord, the respondent number 9 was supposed to file an affidavit stating that they had shifted the hot mix plant because of the pollution that was being caused.
Then it will not survive.
Yes.
6 and 8, my lord. I have already filed a fresh objection statement with verifying affidavit. And my lord, the petition itself has become infructuous because of annexure A what I filed, where the respondent number 4 has passed the orders.
You are 6 and 8.
I'm for 6 and 8, my lord.
In this case, I am for respondent number 4 representing the Karnataka State Pollution Control Board, my lords. On 16/8/24, the environment officer of the regional office Kolar of the respondent herein conducted again inspection of the hot mix plant. At the time of inspection, it was observed that the hot mix plant was not operating and Shri Mitesh Kumar, helper, was present and informed that the unit was not operating since from 4 months, my lords.
You want to go somewhere else for inspection? You are in a hurry to go somewhere else for inspection? Are you in a hurry to go somewhere else for inspection of another unit?
No, my lords.
Yes.
Yes, my lord. Lord, the only prayer in the writ petition is to give the direction to respondent number 4 to close the establishment of that ready mix plant of 6 and 8, my lord. 6 is the operator here, who is the sister concern or a parent company is 8, my lord.
Yes.
Respondent number 8. Such order has already been passed by respondent number 4.
Let us see where is that.
It is at annexure A, my lord, page number 11. Annexure A and Annexure B passed under 2 acts, my lord, air pollution and water pollution. At page number 15, the first point, my lord, the occupier Lanco Hoskote Highway Limited to close down the operation of hot mix plant at survey number so and so, so and so, so and so. This is the only prayer in the writ petition, my lord. So therefore, it become infructuous now.
Yes, madam. Pollution control. What do you say now? What do you say now?
It is not working still. We already make inspections, my lords.
No, we are not working from March 2024 itself, my lord.
Number 8 is not working.
My lords.
Why?
It's number 6, my lord.
Number 6 is not working.
Yes, my lords, not working.
My lord,
Pursuant to this order, it is not working.
You know, we stopped operation in the March 2004 itself, my lord.
So that is exactly what she is saying.
Yes, my lord. During the inspection itself, they have identified that we are not operating.
Yes, my lords. During the inspection, we identified, my lords.
You have stated somewhere in the affidavit.
No, I didn't file affidavit. I'll file.
I have stated in my objection statement, my lord.
My lords.
What's your good name?
My name Shailaja, my lords.
For board. What do you say orally? That when
On
you
16/8/24, my lords.
when you inspected the unit,
On 16/8/2024.
unit of number 6.
Yes, my lord.
R6.
R6 and R8, my lord.
But R8 is transferring.
Now, yes, my lord. R8 is the parent company of 6, my lord.
So on 16/8/24, it was not functional.
Yes, my lords.
We'll record your statement.
Yes.
Senior out of station, Lordship.
Senior counsel can't restart this. The unit is already closed.
I'd like to take the attention of this honorable court, my lord, to page number 16 of the petition, my lord.
16 of the petition.
16 of the petition, my lord.
This was PIL.
Yes, my lord.
Yes. So prayer.
Yes, ma'am. Main prayer. I may be permitted to read, my lord. Issue a writ of mandamus or any other writ or direction directing the respondent authorities to stop functioning of the respondent unit at survey number so and so and shift to some other location immediately as prayed for by the petitioner by representation dated 4/12/2013. my lord. It's already done.
Shifted.
No, we have already closed, my lord. There's no question of shifting. We have completed our work and we have already stopped. It's a highway work, my lord.
Why your mouth is closed? Unit may be closed, but you are also not speaking.
Senior.
Rightly closed. Everything is rightly closed. Submissions are closed. Unit is closed. And we are closing the petition also.
Yes, Lordship.
Everything is closed. Where is your senior?
Senior out of station, Kanakpura.
Out of Karnataka?
Kanakpura.
Kanakpura. Why has gone there?
New filing area.
Little louder. Be free in speaking before the court. You are a lawyer of the High Court. If you don't speak, what will happen? Whole High Court will go silent if you don't speak. So what do you want? Tomorrow we'll keep?
Yes, Your Honor.
Tomorrow at 11?
Pray a week. 10.
No, week.
And
Thursday,
After
Lordship.
week, whole High Court is going to close. for
Thursday, Lordship. Thursday, Lordship.
Tomorrow.
Tomorrow also senior Lordship.
So then you have heard the thing. It is every prayer is satisfied. When your senior will come?
Thursday, Lordship.
Thursday.
Yes, Lordship.
Today is what? Thursday is 17.
Yes.
No, 17.
17, Lordship.
17. On 17th 11. At 11 o'clock. Learned advocate, Mr.
Naveen Kumar, Lordship.
Naveen Kumar.
My senior name, Naresh Santosh.
No, your name.
Naveen Kumar.
Naveen Kumar prays for time on the ground that the senior has gone to Kanakpura. Why?
For filing new case, Lordship.
For marriage.
New case, OS.
For new case.
Yes.
Filing. What will happen to this case? Since how long you are practicing, Mr. Naveen Kumar?
1 year trial court only, Lordship.
No, you are practicing here since how long?
Only in city civil court or trial court only, Lordship.
Since how long?
1.5 years, Lordship.
1.5.
Not High Court, Lordship. High Court ಅಲ್ಲಿ practice ಮಾಡಿದ್ದಾರೆ.
Anyway, we will not waste the time. On Thursday, 17th at 11 o'clock. What is
My lords, at 2:30 is for Thursday 2:30.
Your presence is not needed. Not 2:30.
And again, there is no scientific evidence also, my lord, for all the allegations, whatever is made in
They are made by
Nothing remains.
Culture High School.
Nothing remains. Only because
Speaking
you are not
adjournment.
able, you are not speaking anything to the court.
Humbly seeking adjournment, Lordship. Thursday, Lordship. Thursday, Lordship. Kindly
Thursday
seek-
to रखते हैं. This Thursday, 17th.
This Thursday, Lordship.
This Thursday.
Yes, Lordship.
Any difficulty?
My senior will come on Thursday,
We
Lordship.
will wait for your senior and
Close ಆಗಿದೆ.
only that much we can say. You also come with your senior. Don't go to city civil,
Okay, Lordship.
right?
Right, sir.
God bless me.
110, Mr. Krishna yes.
Appearing for the petitioner, my lord, sir.
For the respondent number
Yes,
2 in this
110.
matter, I appear for respondent number 1, my lords.
For the petitioner, my lord, sir.
Not to take any action insofar as my lords.
They want to widen the highway.
Lords, yes, please.
Already widened.
No, my lords, This now matter, what had happened is,
But who is for petitioner?
is on.
My lords, I am for the petitioner, my lords.
Very good.
The aggrieved party has already filed writ petition and my lords, the learned single judge has passed the order, my lords, saying the interim order has been passed.
What?
Or my lords, the notification was under challenge. The learned single judge has stayed the order, my lords.
Stayed.
My lords, he has directed not to precipitate with the matter, my lords.
So this will not survive.
This will not survive, my lords. In this matter, my lord. He is one of the devotee. Petitioner is one of the devotee. He filed a PL here. And respondent number 5 is the temple. Temple authority filed a writ petition before single bench of this honorable court. There is a stay order on 2nd September 2024.
My lord, sir, here there is an additional pleading before this honorable court that the card street, which is now subject matter for widening, my lord, sir, is an integral part of the temple, my lord, sir, which has been a pleading before this honorable court, and an application for amendment has been preferred in that regard. Until, my lords, the writ petition would be disposed of, this petition may be kept in abeyance, my lords, sir, if your lordships would please to do so.
Pass on the order, my lords.
Petition is to consider the representation, my lord. If my lord were to see the representation dated 19/12/2022, in which they are seeking for dropping of the proceedings pertaining to widening of the national highway.
Who filed the petition?
My lord, sir, respondent number 5 in the present writ petition is has preferred writ petition before the learned single judge.
Same temple.
Same temple. And obtained an interim order as well. May I pass on the interim order?
The petitioner in this public interest petition stood aggrieved because of the action on part of the respondent number 1, Union of India, Ministry of Road Transport and Highways, whereby the NH 169 capital was sought to be widened. The widening had an effect of including the lands of Car Street and also the Nagvana of Maho to Bara Sri Ananta Padmanabha Temple, Sri Kshetra, Perdur, Udupi district. It was claimed that this would cause permanent and irreparable loss to the property of the temple and will make it difficult worshipping the devotees. Make it for the devotees difficult to worship Full stop. The prayer was made to issue to direct respondent number 1, Union of India, and respondent 2, National Highway Authority of India, to drop proceedings pertaining to the widening of NH 169 capital stretch, which abutted Mahatobra Ananta Padmanabha Swami Temple. It was further paid to consider the representation dated 9/12/22 submitted by the temple devotees. When the petition came up for consideration today, learned advocate Mr. for
Respondent number 1, my lords, Union of India.
So and so and so, number 1 Union of India pointed out that the Mahatobara Sri Ananta Padmanabha temple, that's respondent 5 in this petition, filed another writ petition, another independent writ petition,
Please.
whereby the notification of the National Highway Authority seeking to acquire the land to widen the same, to widen the road, was challenged. Full stop. Learned single judge
An order dated 2/9/2024, my lords.
by order dated 2/9/2024, passed in the said writ petition number 24006 of 24, has directed the respondents not to precipitate, has directed by of interim relief, not to precipitate the matter in respect of the property in question till the next date. Full stop. It was stated that said interim order is in operation. Full stop. Now that on a single of this court has passed interim order as above in independent writ petition involving the same subject matter, and that the merits are large open before on a single judge, the court is not inclined to exercise its public interest jurisdiction to entertain the present petition. Learned paragraph. Senior advocate Mr. So and so, who appeared through video conferencing, could not dispute the factum of filing of the writ petition by respondent 5 temple and passing of interim order as aforesaid by learned single judge. In view of above facts and development, the present writ petition is not entertained and stand disposed of accordingly, without going into the merits thereof.
Great, sir.
So 111, Mr. Venkatesh Dalwai.
Your file reply, madam.
Please,
Yes.
Where is that? Could not find it.
My lord, we filed it in the office on the 9th of April. My lord, the rejoinder has also been filed.
7.
Passing on the rejoinder.
It is.
This is a rejoinder. Rejoinder.
Rejoined.
Argument ಮಾಡೋದು ಅದೇನು?
But the annexure A, page
In
40,
paragraph 10, they are saying that the impugned government order does not direct or compel the public
no,
process.
they do it. Please come to annexure A, page 41.
Kindly, my lord. Lordship, may kindly see your lordship's order, my lords, based on which this order was issued. Your lordship's order dated, my lords, 27th February 2025, my lord.
Yes.
Your lordship, para 2, my lord. The public interest litigation herein is advocate enrolled before the Karnataka State Bar Council, who is filing this present public interest, seeking to raise an issue about the decision on the part of the respondent government in directing, thereby compelling the public prosecutor to withdraw the criminal case in breach of section 21 of the Criminal Procedure Code. It is the case of the petitioner inter-alia that several criminal cases have been registered with different police stations across the state between so and so and so. Was 43 cases are selected to withdrawn. This is important. It is alleged that 43 cases involve highly influential personalities such as former ministers, member of legislative assemblies, presidents, and other persons holding high offices. Then, my lord, the prayer is to, first of all, my lord, not even one MLA, minister, or nobody is involved in this case, my lord. It's all general public, my lord. Then, if I may request, my lord, your lordship, paragraph 4.1, my lord. The decision of the Honorable Supreme Court, my lords, got it, my lords? Paragraph 4.1, my lord. The decision of the Honorable Supreme Court in the case of S.K. Shukla and others was pressed into service. More particular observation made in paragraph 32 thereto submit. It is settled law that the withdrawal of prosecution is a function of the public prosecutor. Ultimate decision to withdraw from prosecution is his. It is observed that before an application is made under section 31, public prosecutor has to apply his mind to the facts of the case independently without being subject to other side influence. It is observed that the public prosecutor cannot act like a post box to act at the dictates of the state government. Having relied upon section 321 of CRPC, it was highlighted the learned advocate for the petitioner that the department so and so have sought for an opinion and given order dated 1510 was not a fit case for withdrawal, my lord. Then, my lords, paragraph 5, we therefore issue notice pursuant to the cabinet. Now, my lords, this is based on annexure B is sought to be relied in the writ petition, my lords, where this honorable court had passed an interim order, my lords, that your lordships will get it at page number 44. At the bottom of page number 44, my lords. In view of the aforesaid order passed by the division bench and this honorable court, as well as the decision of the Supreme Court in so and so, the interim order date is modified and is directed the state government shall scrupulously follow the direction issued by the apex court in the case of so and so. It is made clear that the order date is so and so, not to apply to withdrawal against sitting or former members of parliament, legislative assembly, and the same will be governed by the decision of Supreme Court in Ashwini Upadhyay. So therefore, my lord, this judgment based on which has been applied, my lords, applies only to sitting legislators, member of parliament, and former. In none of these cases which has been sought to be withdrawn, my lord, without contradiction, it is against any one of them. They are all general public. So therefore, my lord, the submission made before your lordships, as well as the interim order which has been sought to be relied upon, my lord, does not apply. Now, my lord, and this is withdrawal of prosecution under 321 is not a case of public interest litigation, my lords, unless it is to be shown that this interim we have violated the Supreme Court judgment. Scope of section 321, my lords.
Argument ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Should I begin? Are you arguing or should I begin? No, but you said preliminary submission, but you are arguing the matter.
So therefore, regarding maintainability of the public interest, my lord, that's my preliminary objection, saying that, my lords, a PIL challenging 321 order cannot be a subject matter of public interest litigation, my lords. Especially in view of the fact that, my lords, it does not pertain to annexure B or MPMLA, and a false statement has been, I mean, incorrect, I would stand corrected, my incorrect submission, my lords, was sought to be stated, saying that it is pertinent to MP and MLA, my lords. So therefore, my lord, my preliminary objection is regarding the maintainability of the public interest, my lords. And no public interest is involved in this as such, my lords, in filing is public interest.
So we reserve.
My lords, on merits, my lords.
Lords, so far as, my lord, there is one statement which is made against the petitioner.
He is saying that your petition contains a wrong statement. That
No.
Yes, I'll, your lordship, may kindly see.
Lord, I thought
No, your lordship, just
he'll
one
allow me
para.
to make submissions. I thought he'll allow me to make submissions.
You are here.
10.3, I'll just point out the incorrect statement, my lord. It is submitted that despite the interim order in WP number so and so against first respondent around 43, page 14, my lord, page 14. Page 14, 10.3. It is submitted that despite the interim order in WP number so and so against respondent around 43 new set of criminal cases were proposed to be withdrawn from prosecution as recommended by subcommittee in the previous cabinet so and so. These 43 cases include cases against former MPs, MLAs. Therefore, the same has been placed before the cabinet for consideration. So this is totally factual, incorrect statement, not even one MLA or MP. And cabinet note, which is a confidential document, my lords, has been placed before your lordships, and he's saying that I will not disclose the source of this information. And one other important, my lords, he filed an application for under the Right to Information Act of the cabinet note that was rejected thrice. He does not disclose that also.
What was rejected?
He has applied for the cabinet note, my lords. We do not give it to him. We reject it. He does not disclose. But unofficially, he gets somehow, my lords. He says that I will not disclose how I got it illegally. Annexure R1, my lords.
Lord, if my friend has rested, my lords, I can begin my
I'll just
argument.
make my preliminary submission. Just
Preliminary, you are arguing as if you are arguing on main.
maintainability, only regarding public interest maintainability. My lords, annexure R1, page 14 of the statement of objections, my lords. Statement of objections. Annexure R1.
Page
14, my lords.
information.
To Girish Bharatwaj, who is a petitioner here in my lords, Sheshadripuram, information so and so, in connection to the above cited application, your application under reference seeking information so and so, no provision to furnish information sought for you as per section 81J so and so. You have filed the objection with regard so and so, it has been rejected, my lord, against which he files an appeal, my lords, at page 16. Page 16, order, my lords. Page 16, middle, my lords, 8th January 2025. 8th January in the middle, my lords. 8th January. The appeal was taken for inquiry on 8th January, wherein the appellant was absent. The public information officer in his statement submitted the information sought for cannot be furnished, so and so, so and so. The appeal has been disposed of. Then page 18.
Page 54. Page 54 of the writ petition. These are two cases against a former sitting MLA and a former MLA. Page 54, my lords, in the writ petition. Page 54, Roman 3.
For Roman?
Roman 3, my lords, page 54.
Withdrawal of two cases.
Yes.
What is that?
Two cases, annexure, are submitted for approval to take permission from the Honorable High Court as recommended by Cabinet Subcommittee in its meeting held dated 5/9/2014. That is number one.
Page? 50?
Sir, page 54, 1, 2, 3.
54 and 55 statement.
Yes, there are two cases against former MP and MLA. Against former MLA and MP.
Page 54.
Sir, 54 is annexure after Kannada translation.
Both former MLA.
Yes.
Former MP.
MP. So it is an incorrect statement that no MLA's case were involved. It is sent because, my lords, the apex court created a special court, which your lordships are designated as special judge, my lords. It was sent to him, number one. Now, secondly, my lords, so far as this cabinet subcommittee confidential meeting, my lords, proceedings which are placed before the your lordships as part of Annexure C. My lord, how the apex court has dealt with similar situation, I am placing a judgment of the honorable apex court. What it says. They don't dispute the authenticity of the proceedings. They don't dispute the genuineness of the document what I have filed. Paragraph 34 and 35. This is based on the Constitution judgment, my lords, bench judgment. Please come to para 34, my lords, at the end. I have served a copy to the respondent.
Which one?
Sir, Roman 3. 2013.
Which is it?
But it's paragraph 34 end, last 3 lines. Even though the complaint was bogus, however, sale deeds are annexed along with the though illegally collected by someone has not been found fabricated documents. It is settled proposition that even if a document is procured by improper or illegal means, there is no bar for its admissibility if the relevant and genuineness is proved. If the evidence is admissible, it is does not matter how it has been obtained. However, as a matter of caution, the court in the exercise of discretion may disallow certain evidence in a criminal case if strict rules of admissibility would operate unfairly against the accused. More so, court must conclude that it is genuine and free from tampering and mutilation. This court has repelled a contention that obtaining evidence illegally by collecting, using a tape recordings or photographs offends Article so and so. My lord, unless they say that what I have produced is fabricated before your lordships, which they don't say. My lord, apex court says, my lords, what cabinet note says is that the opinion of the prosecutors, government and the law department, they have rejected the withdrawal of the cases because of the assessment of evidence. Now, if I have to fabricate something, then produce, my lords, they can take an exception. In fact, it is their duty to produce, which they have not done it. So therefore, my lords, the apex court has paragraph 34 and 35. I will lay down like this. In the statement of objections, they don't say that the document, the cabinet subcommittee report or whatever they call it, in the era of transparency, something which is not suitable to them, they will not say, they should not say that it is confidential. This is the rejoinder I wanted to explain, which I have filed an affidavit. And also I have quoted the case law. Now please take the memo of documents, which I have produced on the last 15.3, lordship. I'll not take more than 2-3 minutes, my lord.
Memo of documents.
Memo of documents, my lords. Additional document 15.3.25. I'll quote it. Additional notebook.
Yes.
My lord, please see the kind of application filed in a case where 154 accused are there, where the police station was ransacked. Police were beaten black and blue. UAPA Act is invoked. Now, please see the kind of application which is filed and kind of orders are passed by the learned magistrate. Test is the prosecution, the public prosecutor will have to initiate. Page 1, my lords. The application, one sample application are produced. Page 1.
It is some letter from the director.
No, my lords, page 1, page 1. Page 1. It's application number 321. Memo dated 15/3/25, my lords.
24th March.
Yes, I am sorry. I stand corrected. Page 1, your lordship. This case pertains to serial number 6 in the list of cases where the Deputy Chief Minister recommends for withdrawal. Fortunately for us, even that is also recorded in the note sheet. I'll point out that. Please see the first page. Except quoting the government circular, my lord will find it para 3. My lord, no satisfaction of public prosecutor is there. My lord, law is well settled. It is the prosecutor alone who has to initiate this.
No, where is paragraph?
My lord, para 3 in the page 1, my lords, an application is filed.
So
please take para 3.
How does it start? The prosecution.
My lord, the prosecution further submits.
Correct.
In the meanwhile, Government of Karnataka has withdrawn the above case against the accused by notification dated so and so so and so produced. Next is, therefore, I leave it to the learned trial court. You may pass deemed fit orders. Well, this kind of satisfaction is not there. So therefore, the statement objections that government order is only a recommendation is incorrect. The learned prosecutor would say that the government has directed me, therefore I am filing this.
So whose satisfaction not reflected? Court satisfaction.
No, the public prosecutor has to satisfy first. Then the court will have to satisfy itself. Under the scheme of CRPC, there is no role of government. Please see the orders which are passed. Before filing the petition, the orders are passed. Page 8, for example, if your lordships were to come to the very same compilation, 2 lines orders are passed. Page 8, 9 and 10. Of the same compilation. Up to 12, your lordship would get it. Except quoting this government order of the same compilation, your lordships on the memo of documents.
Same compilation.
Same compilation, page 8 to 13. For example, my lords, page 9, learned APP has filed an application under 321 seeking to withdraw the case against accused person in respect of all the offences. It is in the application it is submitted specific order received from the government to withdraw the cases, including the present case. I mean, this is not expected, my lord. If this is not against the public interest, my lords, and what else could be the public interest?
So the satisfaction is not reflected.
No, except quoting the government. Therefore, the statement of respondents that government only recommended, they did not command the withdrawal is incorrect. My lord, kindly see how Justice Krishna here has dealt with this issue. Page 13 of the same compilation. Same, your lordship just now saw it. Please come to page 15. Page 15, my lords, on the same compilation. On the same, your lordship just now saw the order on the same line. Page 15. I'm placing reliance on 77 4 SAC 448. Page 15, your lordship. The statutory responsibility for deciding a withdrawal of the case squarely vests on the public prosecutor. It is not negotiable and cannot be bartered away in favor of those who may be above him on the administrative side. My lord, what else is required? Page 15, your lordship.
Where you are reading?
My lord, page 15, after 6 lines, my lord, the statutory responsibility for the prosecutor to withdraw the case from the case, deciding upon withdrawal squarely vests upon the public prosecutor. It is not negotiable and cannot be bartered away in favor of those who may be above him on the administrative side. CRPC code is the only master for the public prosecutor, and he has to guide himself with reference to CRPC only. So guided, consideration must be to weigh him whether there is a broader cause of public justice advanced or a retarded withdrawal or a continuance of a prosecution. As we have already explained, public prosecutor may be such wider conception than the justice in a particular case. Here, the public prosecutor is ordered to move the withdrawal. This is not a proper for a district magistrate to do so. Indeed, it is not proper to have a public prosecutor ordered about it. It is entirely within the discretion of the PP. It may be open for the district magistrate to bring the notice of the public prosecutor materials and suggest him to consider whether the prosecution should be withdrawn or not. He cannot be commanded where he can only commend. In this case, the facts clearly bring out the prosecutor obeyed and not acted. Therefore, statutory responsibility vested in him was not properly exercised. If he comes to the conclusion that on the material passed on him, the case deserves to be withdrawn, he may initiate in this behalf. Likewise, the court may initiate action in this behalf. Likewise, the court's order in this case is a puzzle to us. Order says records have been perused by the court. District magistrate has directed the prosecutor. Prosecutor has duly obeyed, and district magistrate has also mentioned the superintendent of police has also reported him to withdraw the case. This kind of, and now, my lords, let us see, my lords, whether there was a political intervention in this particular case or not. May I request, my lords, kindly take the compilation which I have produced at Annexure C, page 49. It starts. Please come to item number 6. Who are the persons who are recommended for withdrawal?
Page?
My lord, page 95, my lord. I'm sorry.
Of the petition.
Yes, yes, ma'am. 96, if lordship. Column number 2. 96, my lord. 96 is part of annexure. Annexure C. Member of committee formed under umbrella of Anjuman-e-Islam Hubli gives a representation to Deputy Chief Minister, and D.B. Chowdhury, President of Dharwad Vivida Dalita, so and so, representation to the Malad. It should have been Home Minister, but Chief Minister. All these cases, the withdrawals are initiated at the instance of somebody. It is not the accused who have requested that withdrawal should be initiated, because they are innocently hauled up in these cases. So, Malad said, if this is not a political intervention, fortunately, at least this records that. So serious cases are being withdrawn. Where 154 accused Malads in this case are facing the prosecution. And prosecution department says, no, we want to prosecute them because the assault was gruesome on many police officers. So therefore, Malads, if this is not a public interest litigation, what else could be, Malad? So therefore, my humble submission is, Malad, my prayers may be granted.
Just take 2 minutes. I'm just sorry, just 2 minutes. Page 54, well, my learned friend made a statement, my lord, saying that 2 cases pertain to MP and MLS, which is again factually incorrect. Your lordship, page 54 may be kindly seen. Serial number 1, my lords, to take suitable decision for withdrawal of 43 cases, annexure A1. What my learned friend is saying, talking about 3, withdrawal of 2 cases, so and so, to take permission of the Honorable Court and recommend, because 2 cases pertain to MPs and MLA. Serial number 1 is what we are concerned with, which does not pertain to MP or MLS. So therefore, my lords, even now, an incorrect statement is ought to be made that annexure A does not pertain to any MP or MLA. Second, my lords, second point is, my lords, he does not disclose the source of information. That is one aspect. He conceals the fact that he has applied and is not got is a second aspect. No, my lords, whether the state government can withdraw or not is covered by the judgment of this court, my lords. With the court copy. The role of the state, limited role of the state while considering under section 321, my lords, is what has been examined. Other side. You know it. Your lordship may see, my lords. Government order recommending withdrawal of prosecution under 371 is not contrary to law. My lords, this is the heading, my lords. I'll just think government order recommending withdrawal of prosecution on 321 is not contrary to law. Withdrawal section, just permit me to read 321, my lords, which is called out in page 1 itself, my lords. Can I read it? 321, my lords. The public prosecutor or assistant public prosecutor in charge of a case with the consent of the court at any time before the judgment is pronounced, withdraw from the prosecution of any person either generally or in respect of any one or more offences which he has tried. Upon such withdrawal is what it says. Can I take my lords to para 16, page number? Can I page number, my lords? Running page number 40, my lord. 41, my lord.
These judgments are not in dispute. Even I want to rely upon the
Let
very
him
same.
rely. Let me complete the judgment.
Even I want to rely upon the very same principle. The point is, if the prosecutor and the court are concerned for withdrawal, then what business the government has got in between?
No, let me
Why
read
should
it.
they direct
No, what business the Supreme Court has said, what business I have. I'll read what the Supreme Court has said. What is the business? Para 16, what is my business? I'll answer to my para 16. In Rajendra, page 41, my lords. Page 41, para 16. In Rajendra Kumar Jain versus State, there was an application for withdrawal of prosecution against George Fernandez, chairperson of so-and-so. So-and-so has filed accused rousing resistance from so-and-so and participating in conspiracy to do acts which are resulted in destruction of property. After emergency was revoked, the special public prosecutor filed an application of so-and-so in view of the changed circumstances and public interest. Given the political background of the dispute, two judge bench so-and-so, Chinna President, highlighted the importance of independence of a public prosecutor in the exercising the power under section 321. In this context, withdrawal of prosecution, which matters of public policy are involved, the court held. In the past, we have often known how expedient and necessary it is necessary in public interest for the prosecution to withdraw from prosecuting arising of mass agitation, communal rights, regional disputes, industrial conflicts, students' unrest. Whenever issues involve emotion, there is a surcharge of violence in the atmosphere. It has often been found necessary to withdraw from prosecution in order to restore peace, to free the atmosphere from surcharge of violence, and bring about peace of settlement of issue and preserve calm which may follow from the storm. To persist with prosecution where emotive issues are involvement in the matter of indicating the law may even be utterly counterproductive. An elected government sensitive and responsive to the feeling and emotions of the people will apply justified if for purpose creating atmosphere of goodwill or for the purpose of not disturbing the calm and dissidents in the decide not to prosecute the offenders involved or not to proceed further with the prosecution already launched. In such matter, who but the government should decide in the first instance whether it should be baneful or beneficial to launch or continue prosecution. If the government decides that it would be in public interest to withdraw the prosecution, how it is the government to go about this task. Under the Code of Criminal Procedure, it is the public prosecutor that has to withdraw from the prosecution. It is the court has to give its consent to such withdrawal. It is he that is entrusted with the task of initiating proceeding for withdrawal from prosecution. But where there is such large and sensitive issue of public policy are involved, he must, if he is right mandate, seek advice and guidance of the policymakers. His source of information and resources are very limited, unlike those of the policymakers. If the policymakers themselves move in the matter in the first instance, and indeed it is proper that they should where matters for momentous public policies are involved, and if they advise the public prosecutor to withdraw from the prosecution, it is not for the court to say that the initiative comes from the government, and therefore the public prosecutor cannot be said to have exercised a free mind, nor can there be quabbling over words. If ill-informed but well-meaning bureaucrats chooses to use expression like the public prosecutor is directed to or the public prosecutor is instructed, the court will not on that ground alone certify the large issue of public policy by refusing its consent on the ground that public prosecutor did not act as a free agent where he sought withdrawal from the prosecution. What is at stake is not the language of the letter or the prestige of the public prosecutor, but the wider question of policy. The court in such a situation is to make an effort to elicit the reason for withdrawal and satisfy itself that the public prosecutor was satisfied that he should withdraw from prosecution for good and relevant reasons. Thus, the fact the withdrawal is initiated by the government and was held not to vitiate the application so long as the public prosecutor had independently applied his mind. Elaborating on the scope of withdrawal on the ground of public justice and participation amid of expression political offences, the court held that for our present purpose, it is really unnecessary to enter into the discussion as to what political offense expect in a sketchy manner. It is sufficient to say political and government politics and about government, and therefore a political offense is not committed with the object of changing the government of the state or inducing change in policy. So and so Mahatma Gandhi, the father of the nation, was convicted and jailed for an offense against the municipal law. So was his spiritual son and the first prime minister of our country to say so. I'll just skip all that, my lords. Then, my lords, in the middle of para 21, my lords, middle of para 20, my lords, that your lordships will get it at page 45. At 73, my lords, page 45, page 73, my lords, to contend that the court, when in exercise, is page 45, my lords, at para 20, my lords, quoted portion 73, my lords. When an application under section 321 is made, it is not necessary for to assess evidence to discover the case would end up in conviction or acquittal. To contend that the court, when in exercise, is limited power of giving consent and has to be assessed the evidence and find out whether the case would end up in acquittal or conviction would be to rewrite section 321, and it would be to concede to a court of power which scheme of section 20 does not contemplate. The acquittal or discharge order under section 321 are not the same as normal final orders in criminal cases. The conclusion will not be backed by detailed discussion of evidence in case of acquittal or absence of prima facie case or groundless or so and so. All that the court sees is that the application is made in good faith. So and so, so and so, my lords. Then 20 page, my lords, 25.4, my lords. Page 49, my lords, page 49. Para 25.4. My lords got it, my lords, 25.4. The mere fact that.
Choosing password.
Huh?
Choosing password.
Correct. While the mere fact that the initiative has come from the government will not vitiate an application for withdrawal, and the court must make an effort to elicit reasons for withdrawal so as to ensure the public prosecutor was satisfied, so and so for withdrawal of the process necessary for good and relevant. So ultimately, if somebody is aggrieved, my lord, let them challenge that order, saying that it's not for good. It's not a case for public interest under to challenge 321 order, my lord. What does it say? Page 134, my lords, just for a moment. Page 134, page 134, 134. Para 73, my lords. Para 7. Let us now consider the point from practical point of view. My lords got it, my lords. Let us now consider from the practical point of view. Unlike the judge, the public prosecutor is not an absolutely independent officer. He is an appointee of the government, central or state, appointment to conducting in court any prosecution, other proceeding on behalf of the government concerned. So there is a relationship of counsel and client between the public prosecutor and the government. Public prosecutor cannot, without the instruction of the government, a public prosecutor cannot conduct a case absolutely on his own or contrary to the instruction of his kind, namely the government. To take an extreme hypothetical case in which the government is a prosecutor, in which there is a prima facie case against accused, but the government feels that the ground for public policy, or on the ground that law and order, on the ground that social harmony, or on the ground of expediency of prosecution for reasons of the state, the case should not be proceeded further. Government will be justified to express its desire to withdraw from the prosecution and instruct the public prosecutor to take necessary steps to withdraw from the prosecution. Section 321 of the code does not lay any bar on the public prosecutor to receive any instruction from the government before he files an application in this section. If the public prosecutor receives such instruction, he cannot be said to act under the extraneous influence. On the contrary, public prosecutor cannot file an application withdrawal of case on his own without the instruction of the government. Now, in the above hypothetical case, if the government gives instruction to public prosecutor withdraws from the prosecution of the case, later the following course open to him. He can blindly file an application without applying his mind to the facts of the case. This is not contemplated under section 321 of the code. He himself may apply his mind to the facts of the case, may agree with the instruction of the government and file the application stating the grounds for withdrawal. That is what is contemplated by section and has been done in this case. Or he may tell the government, if for a good reason for the prosecution, a conviction is almost sure and I do not agree for the cases should be withdrawn, I am not to file the petition for withdrawal. In the present case, prosecution will have to return the brief and perhaps resign from, for it is the government, not the public prosecutor, who is to know the larger interest of the state. Let us see if the so and so, so and so. Ultimately, my lord, this has to be done at the magistrate, not at in a public interest litigation.
But only, I'm sorry.
Or
May I make 30 seconds?
Pardon?
Or 30 seconds. Just one clarification. There is a en masse order for withdrawal. It is not the question of Each case is threadbarely considered, number one. Secondly, the reasons of public policy, peace and tranquility is not found in the order impugned. My lord, they cannot supply reasons what is not found in the order. My lord, 1963 Supreme Court, Mohinder Singh case is very clear on this issue.
Heard learned advocate Mr. Venkatesh Dalwai for the petitioner and learned Advocate General Mr. Sasikarna Setty, assisted by learned advocate, honored government advocate Mr. Miss Srimati Nilofar Akbar, and your name is to mention?
Manthan.
And learned advocate Mr. Manthan. He is advocate, government advocate?
No, ma'am.
And learned advocate Manthan. For the respondent state, comma at length, learned advocate party stated that they argued the petition. Finally, they further stated that pleadings are complete and no further are required to be added or supplemented. Resort for judgment.
Grateful.
Very grateful.
ಅವ್ರಿಗೆ 60 ಅಂತ ತಗೊಂಡಿರ್ತಾರೆ ಅಲ್ವಾ ಇದೆ.
Serial number 112, Mr. Mahendra SS.
This can wait.
For consideration of representation on the last occasion, Lordship was pleased to
My lord,
record.
the application has been considered before the filing of the petition itself. An endorsement has been issued. Survive for consideration.
This is not an endorsement. See, my application was processed and it was sent for approval before the secretary. Now the prayer in this petition is, Lord, the secretary should consider the process of approval within a time-bound manner. That is the prayer. Your Lordship may kindly peruse the prayer, page 14, Lord. Issue a writ of mandamus or any other appropriate writ direction directing respondent one, the Secretary Government of Karnataka Department of Mines and Geology to consider the representation submitted by the petitioner dated so and so, and accord approval for proposal of the petitioner for grant of building stone. Under the amended provision, Lord, the processed application has to be approved by the secretary. Now it is pending before the secretary. Secretary has to give approval or reject it.
Consider the representation in accordance with law. Then my lord may direct for the representation to be considered in accordance with law.
No, this is not the endorsement. This is not the endorsement.
My lord, I'll take it back. My lord, the representation is dated 24/2/2025. We will consider that in accordance with law.
That's all.
The prayer is to consider the representation.
In a time-bound manner, let them consider. I have relied on one judgment, Lord.
Yes, my lord, a similar one which my lord was pleased to pass.
It is covered by the judgment, Lord. The Lordship was please to direct the secretary to consider within 2 months from the date of
Right. Filed under Article 226 of the Constitution. The petitioner has prayed by way of this petition to direct respondent one as the Secretary, Government of Karnataka. Department of Mines and Geology, to consider the representation of the petitioner dated 24th February 2025. The further prayer is to accord approval to the proposal of the petitioner for grant of coring lease for building stone in survey number 180 or the area to the extent of 3 acres and 10 gutas at Arekere village, Arasikere Taluka, plus Hassan district. As per Rule 8B of the capital B, Karnataka Minor Mineral Concession Integrated Amendment Rules 2023. Learned advocate for the petitioner, Mr. Mahendra, relied on in support of the prayer, the decision of this court in M.N. Subramania versus State of Karnataka and others, which was writ number 29835 of 2024. Decided on 3/12/24. When the petition came of consideration, responding to the prayer of the petitioner, learned additional government advocate Srimati Nilofer Akbar stated and submitted to the court that the representation of petitioner dated 24 February 25 will be considered by the Secretary, Government of Karnataka, Department of Mines and Geology, in accordance with law and on merits within 6 weeks from the date of receipt of the order. Full stop. The above statement satisfies the petitioner. Therefore, granting relief to the petitioner to the extent of the statement made by learned government advocate, it is directed that the representation of petitioner dated 24th February 25 shall be decided and shall be considered and a decision shall be considered and a decision in accordance with law shall be rendered by respondent secretary within a period of 6 weeks from date of receipt of the order. Full stop. The present petition is accordingly disposed of with observation that this court has not gone into the merits of the case of the petitioner, nor has expressed anything on merits.
Organized. 113.
This can wait after vacation. 20th June. वापस लेना है. This is to be given back. इसका नहीं है, उसका पहले.
It's number 37. Srimati Nayantara Vidhi.
Petitioners counsel. Matter pertains to not deemed extension of quarrying lease pertaining to a non-specified minor mineral, building stone, by virtue of the amendment. Lordship takes the petition. Right? I had 2 quarry leases.
Called after vacation, my lord.
This can wait. 12th of June.
Case number 38. सुने या ना
My Lord, appear for the petitioners.
My Lord, I'll file a response in this, my Lord, may call it after vacation.
After vacation, 30th June, as requested by learned additional government advocate with no objection from the petitioner.
Serial number 39.
In serial number 39, my lord, have been authorized to represent respond number 2, my lord. The draft statement of objections has been sent for approval, my lord.
6 time to file the statement.
My lord,
of objections,
yes.
stand out.
A week's time may be granted.
Yes.
My lord, the urgency is, my lord, the NGT is proceeding with the matter, my lord, may be taken up anytime next week. It is with regard to the compensation which has to be deposited, my lord. Last time it was taken. Date was fixed, my lord.
Not possible.
Any time in the first week of June, my lord. 2nd of June is the date which is being fixed by NGT. 2nd of June,
Your
the NGT
Lordship,
matter.
the petitioners had agreed to deposit an amount of 117.35 crores, Your Lordship, as per the NGT order. As in the order dated 9/12/2024, Your Lordship, before this Honorable High Court. They have not yet made that deposit, Your Lordship.
My lord, we are agreeing to make the deposit. The issuance of the commencement certificate, my lord, whether it has to be fresh commencement certificate or the renewed commencement certificate, that is the question which is being involved.
Enjoying some relief?
Please, my lord, we are seeking for a stay of the order which is being passed.
No, you are enjoying some relief today?
No, we are not enjoying any relief, my lord. Maybe taken up any time end of this or the first of the vacation, my lord.
1st July.
Obliged, my lord.
Number 40. To B Vachan.
Lords, wide order dated 24/12/2024, my lords.
My Lord,
Deputy
I had
Commissioner
to-
had been to serve the copy.
My Lord, the documents are in Kannada, my Lord.
Class will be supplied before the next test, stand out to 3rd July.
My request for a date in June, my lords, for reason, my lord, is this. We have obtained all the licenses, my lords, and established a factory by setting up spending a sum of rupees 18 crores, my lords. All the licenses are in place other than the license to be issued by the village panchayat, my lords. Initially, they issued us the license to put up the construction also. I spent 18 crores, my lord, out of which 14 crores have taken a bank loan. I'm unable to start the commence production. Any date, my lords, in June, my lords, is all I would request.
Not possible.
Number 41.
Obliged, my lord.
To Balraj AC.
Yes, any urgency, Mr.? No urgency. Learned counsels for the witness said there is no urgency.
One submission, my
Go to
lords.
4th August.
Just one submission, my lords. I had filed an application for production of additional facts that was not listed along with this petition today.
Not listed.
Not listed.
So on the next day, the application file for production documents will be listed. Check.
42.
I'm for the
42.
respondent.
Where? 42. 42.
42 and 42.1.
Your Lordship,
Both
we
are
have,
appearing, all parties are appearing.
Lordship, we have filed our objection for the delay. And in the connected matter, my lord, the copy is not served. We'll take out notice, your Lordship. In the last occasion also, I made the submission.
So notice will have to go.
My lord, I'll take,
42.1. 42.1 notice returnable on
I'll take out notice, your Lordship.
4th July. 4th July. And 42. What about 42?
42 notice have been served.
Notice is served. 228 delay. That can be where is the appellant? You are the appellant, state. You are appearing for all.
Respondent, your Lordship.
All.
No, my lord, the R1. It's only one respondent.
Number
your
2,
Lordship.
society is to who appears? South. Goes to third learned additional government advocate Chandrasekhar for the applicant. Learned advocate Miss for number 1
Yes, your Lordship.
and Franco for number 1. The rest of the respondents are served with the notice of this court, however, have not chosen to appear. This application is filed seeking to condone the delay of 228 days. Full stop. The applicant is stayed, therefore, the delay has occurred in the process of undertaking the administrative procedure when the file is required to travel from department to another department in its hierarchy. Full stop. Consumption of time in the applicant state is inevitable to some extent, viewed from this angle, and considering the principle that the delay has to be considered lenient, case is made out and sufficient cause is shown to condone the delay of 228 days. The delay is condoned, application is allowed. Appeal, any urgency? 10th of June. Appeal may be listed on 10th of June.
Notice. 10th of June. 43 to 48 are urgent. Number 49, state appeal.
Lords, we are pursuing the matter before the single judge. Review petitions been filed by some of the affected parties. So my lordships may kindly have it on 26th, my lords. If we fail there, we'll come back on this.
10 to 26 as requested by learned additional government head office. Okay. 26 April.
26. Number 50, Mr. Nayak VS. 50, Mr. Nayak VS.
Seventh April. 7th July, sorry.
Number 51.
It's for petitioner. It's about this is about not the chess players case, my lords, which your lordships allowed the writ petition and directed my lords payment of 10 lakhs as the compensation from the state. My lords, I actually my lords sought for my lords a seat, my lords, in the other college. It was held that my lords, I am the my lords, the first person to be placed, my lords, in the list. My lords, after considering my lord the entitlement to the seat. My lord, the decision what was laid upon by this court, I cited that my lord, that is it says an additional remedy compensation can be given, but the primary my lords, the remedy which can be granted is for restitution. My lords, now 2 years are my lords are over in the institution where my lords I joined. My lords, the urgency is this, my lord, now that for the 3rd year, my lords, if it permits, my lords, I can join, my lords, a better institution. That's why, my lords, I was trying to move the matter. I was told that, my lord, there are vacancies available, my lords, in the other institution where I could have got, my lords, a seat.
My lord, the KEA has to file their objections in this matter, my lord. It's
now, my lords, 2 years are over, my lords. For the 3rd year, my lord, if the matter can be taken up by Monday or Tuesday, and my lords can be considered in the, my lords, it is, my lord, the already, my lord, there is a decision, my lords, adjudication of the issue involved. To the extent that, my lords, it is held that I am entitled for, my lords, placing as number 1, my lords, in the category. Now, my lords, if where the seat would be available, my lords, it will be data will be available with the state, my lords, and the medical, that is Department of Medical Education, that they can come up with, my lords.
You can take up the review application itself.
Please.
You argue the review application.
Please.
Where is the other side? All are appearing.
my lord, KEA Mr. Ramesh appears, my lord.
Come, let him come.
My lords, they were served, my lords, and I also personally intimated, my lords.
17th.
Please.
Awaiting the presence of learned advocate for KEA.
KEA.
Karnataka Examination Authority in vain from 10 to 17.
And my lords, R4, Mr. Ketty appears, my lords. Ketty appears, my lords. I have served on him. And my lords, also the medical council is served, my lords, by from this court, my lords. His name also can be shown, my lords, in so far as R4 is concerned.
To give
4 is the state. R4 is state.
Yes,
sir. I'm sorry,
Number
R5.
R4 is state.
R5.
52.
Number 52. Say writ petition PAL, Mr. Shivkumar N.
Petitioner.
Now this
Application for
replies filed in this, nothing survives.
my lords.
Nothing survives.
It survives. We have filed application to bring the LRs of respondent number 8, my lords.
Who is number 8?
He is the grantee of the part.
In view of the reply is filed probably, if I am not forgetting.
Sorry, my lord.
Reply is filed.
Not at file, my lords.
Reply is not filed in this. Reply shall be filed before the next date, put up on 12th of June,
That application may kindly be allowed.
which on that day will allow.
Number 53. Sir,
I am for the petitioner.
appearing for R2, my lords.
My lord, it's not, they have given me the affidavits just now.
Affidavit is given by the respondent to learned counsel petitioner today itself in that view.
My lords,
In that view, 6 times, 10 over to 7.
may I be permitted to file this affidavit before this honorable court?
File in the register. 7 July. File in the register. Next.
Number 54.
54 also no reply is filed. Reply shall be filed before the next
Petitioner,
day,
my lord.
10 over to 8th of July.
Restoration.
It's restoration.
Dismissed or non-prosecution, my lord. 54, I am for petitioner.
Why it was dismissed?
That's one office objection. Parties has to sign a PAPAMA A application, my lord, but parties are has to sign PAPAMA A application. But we are informed them they have not come to here to Bangalore. Parties has to sign a PAPAMA A application.
Little louder. Little louder.
Parties has to sign a PAPAMA A application, sir. But
To sign it, learned advocate says that party have to sign for my praise. They may sign it. Stand over to 9th of July. That is correct. What is this for?
But they are not reply from their side, my lord. We informed them already to them. But
What
not
inform?
for the petitioners
What you inform?
to sign the applications.
We do not.
Please allow these applications, my lord.
What application? Tell us, then we'll allow it. What is the application? What is the application? Be prepared. 9th July. This is PIL?
Yeah.
So you are not interested in removing the office objection?
Already done, my lord.
Already done.
Yes, my lord.
Already done.
It's dismissed
How can
on
you,
10
when it is dismissed, how can you remove the office objection in a dismissed matter?
Only one of subjection is that. Only one of subjection is that.
Whatever it is. 9th July. If you don't understand what you are filing, then what can be done, mister? We are not here to teach you. 9th July. Check. Next. ले लो 55 तक ले लो.
Number 55.
I appear for the respondent number 1, my lords.
Appearing for the appellant.
Not appellant. Seniors before another court, my lords. Kindly taken up next week, my lord.
No, it is called out only for argument. This is matter is called, though time is over, we are calling out. What is
My lord,
this?
the learned single judge had set aside the order of the deputy commissioner.
So who said you have to argue?
Pardon?
We are not saying that it is just. Time is over now, take a date.
Next week, my lord. Some urgency in the matter.
What are
22nd morning.
Not possible. 22nd July is possible.
My lord, 22nd is before the deputy commissioner. He will pass orders, this appeal will become infructuous. That's my problem.
Not possible. Stand over to 12th June. Now this serial number 72 is to be kept on 23rd. This 2017 matter. Then 74 also to be kept on 23rd. That's
For serial number 106, my lord.
Serial number 38, my lord. My apologies, there is interim order to be extended, my lord.
38 will be
38 serial number.
38 wherever.
Serial number 100.
I have to be extended. Interim order shall stand extended till the next day. Whosoever is taken.
Serial number 100.
Please.
The date be given. Serial number 100.
Date will be given by court office.
Serial number taken about 230. 230. 230. It will be listed under 230.
230 not the date.
Serial number 63, my lord.
Whenever the date is been given.
Serial number 63, it is for compliance.
Serial number 68, part payment they have made, remaining balance.
Rejected. Yes.
Lordship, serial number 83, Lordship.
83. Yes.
I have served the copy and I may be permitted to file the acknowledgement for serving the copy on accused. Similar matter has been listed on 23rd, Lordship.
So
Serial
23rd.
number 8 of today's.
So 23rd of
Let's-
April.
Serial number 63, my lord.
File in the register.
Serial number 63.
Serial number 106.
68. Serial number 68, the direction is to pay the 27 lakhs, out of which 21 lakhs had been paid by the government. Remaining 6 lakhs is balance. They need in respect of payment.
That's I appear for respondent
Yes,
number 2 to 4, my lords.
Take up.
I complied in this matter, my lords. Duly complied, my lords. My lords, in this matter, my lords, senior is in out of station, my lords, for purpose of personal inconvenience, my lords.
Senior is complied with the order.
We have duly complied, my lords.
Who is?
Respondent number 2 to 4, my lords.
To dispose of.
I am producing the
They are
document.
not here now. Yes.
Serial number 63,
Let's,
my lord.
Let's serial number 7.
No, serial number 1.
Yes, madam.
Well, serial number 71, my lord, similar to serial number 8, my lords. The matter is listed on 23, my lords. Serial number 71, 84, and 85, my lords. Education matters, my lords. Similar matter is listed on 23rd of April, my lords.
23rd April.
Great.
Serial number 6.
The serial number 106, my lord.
Writ petition was allowed in favor of the complainant. SLP was preferred. It was dismissed. Now, my lord, they have to comply the order of the writ petition. Order in the writ petition. I'm requesting for tomorrow at 2:30. Matter pertains to compassionate appointment, my lord.
Serial number 63, my lord. My lord, serial number 63.
Date, my lord.
11th June.
So serial 106, my lord.
11th June.
Serial number 100. It will be tagged with one more connected matter. Serial number 100. Along with one more connected matter. One more connected matter is there. Let it be tagged.
What to be listed on 22nd of June.
Serial
number 80.
23rd of June.
Watch number
The
80.
serial number 106, my lord. 106, my lord, has become infectious, my lord. Regarding the.
I am not listening. Why you are listening?
Serial number.
Out of surrogacy provisions, madam. The 11th single judge permitted a person who is overage, but then it's prescribed to undergo the surrogate system. Now, following the very same order, in other courts also being appeal is filed, madam. Office objection is that the Department of Health have made a party, one and the same. That is the only thing, madam, it is accepted. We posted for issue.
Office option is dispensed with for the time being.
Serial number 6.
Date may fix, madam, we are start for a stay of the charge.
Learned advocate Mr. So-and-so wants date to be fixed.
Agency is the
Bill may be listed on 26th June.
There is, maybe in the month of there is a delay, madam, notice request to be added so that at least we can.
My lord, serial number 63. It is for complaints, contempt matter. I am a retired employee, my lord, and I don't have my this thing. They have not been still settled. As per the court order, they have to comply the.
We are also retiring.